Heather Ann Drogash. People against Heather Ann Drogash, 25B82690, A, B, and C.
Good morning, Your Honor.
Good morning. Your name?
Heather Drogash.
You have 3 charges here. You have a vicious dog, no dog roaming at large, and then no dog license, and you have the right to a lawyer on this. One of these is a misdemeanor, the vicious act. So would you like a lawyer to represent you on this?
No, Your Honor.
All right, I'm going to formally arraign you, and then I'll let you go talk to the prosecutor. It is alleged that on June 28th of 25 at 9 p.m., that you were the owner of a dog that committed a vicious act on Pine Drive near Oakcrest in Brownstown. That is a misdemeanor punishable by up to $500 in fines, 90 days jail, costs or all those. That's count 1. The other 2 are dog roaming at large. That's a civil infraction, and no dog license. That is a civil infraction. Do you understand that?
Yes, Your Honor.
Did you sign an advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. Do you still wish to waive your right to a lawyer?
Yes.
Then or a not guilty plea.
Not guilty.
I'm going to send you to the prosecutor. I'm going to give you, can you tell me what kind of a dog this is?
She is a border collie and Rhodesian Ridgeback. She's 55 pounds, medium.
Okay. I'm going to give you a personal bond, $500. Here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with the victim of the dog bite. You cannot write, phone, see, text, email, or communicate with that individual or have anybody else do any of those things for you or on your behalf. No contact with prosecution, witnesses. Dog to remain, listen very carefully to this, in a fenced-in yard, your home, or on a leash, and equipped with a muzzle, okay, and equipped with a muzzle, and accompanied by you or another suitable adult. Do you understand that?
Yes, Your Honor.
I mean, somebody over 18 that can control the dog, okay? I'm going to send you to the prosecutor. You can speak with her, and then either way, you're going to come back in here and speak with me, okay?
Yes.
Any questions? Okay, we'll see you in a few minutes. Timothy Sean Walsh, 25B148654A and B. Could I have Crystal Wren seated at the table, my right, your left? Crystal Wren over here at the table, my right, your left. Sir, your name?
Tim Walsh.
You're charged with driving on a suspended. We adjourned this until today. Did you talk to the prosecutor yet?
Today, no.
Yeah, you're supposed to do that. Do you want a lawyer?
No, sir.
Okay, you go in and you're going to speak with the prosecutor, all right? The township attorney. And then either way after that, you're coming back in front of me, okay?
Yes, sir.
All right, so you can go right out in the hallway. Thanks. People against Wren, Crystal Denisha Wren, 25B148897A, B, and C. Your name?
Crystal Wren.
You're charged with driving on a suspended, expired plate and no proof of insurance, and you have the right to a lawyer. Would you like a lawyer?
No.
I'll go ahead and arraign you and let you speak to the prosecutor. Then it is alleged that you did operate a motor vehicle on Telegraph near Reynolds in Brownstown on July the 6th of 25 with a suspended license. That is a misdemeanor punishable by up to $500 in fines, 93 days jail, costs or all of those in 2 points. You understand that?
Yes.
You're also charged with expired plate and no proof of insurance. Those are 0 point civil infractions. Do you understand that?
sir. Yes.
Did you sign, read, and understand the advice of rights form here?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. You still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea. $500 personal bond. You don't have to post any money. But here are your bond conditions. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Do you understand all that?
Yes, sir.
Any questions?
I did have insurance.
You go, no, that's, you talk to the prosecutor about it. Okay? Good luck. Either way, you're coming back in front of me. Can you come on in here, please?
I can, Judge.
Thanks. People against Robert Thomas Boyd, 25BA 2557. Your name?
Robert Thomas Boyd.
All right. Mr. Boyd, you have the right to an attorney. I'll be happy to give you one at public expense if you would like one. Would you like a lawyer?
No, thank you.
This, Holy Carter, your name, please?
Caitlin Ford, Farm Professor Township. I do have the ordinance before to knock you have to grab them.
Right, please. I need an order. Probation. Good morning, your name?
Rob Harris on behalf of Brownstown Township.
All right. Did you go out and look?
Yeah, there's no change.
Boyd. Mr. Boyd. You're going to force me to do something that I don't want to do. You're not going to make me lock you up, are you?
I hope not.
Well, come on. You cannot have a dump sitting there in a township. It's a dump.
I've been working on it.
You have not been working on it. We were just out there.
I've worked at it.
Well, what did you do since I went out and looked at the property back on July the 16th? Tell me what you've done.
Okay.
Come on, be specific now. I've got the ordinance officer sitting here.
Cut more brush down,
Where?
on the side yard.
What are you? Side yard. Where are the vehicles? They still there?
Yes,
The
sir.
boat, the trailer, the garage.
We're over at my mechanic right now. I've called him twice and tried to get it over there to him, but he don't have room for it right now. I'll call him again today when I get out of here.
Mr. Boyd. They've warned you before. You've known about this case since at least the middle of April. This is the end of July. I don't know what I gotta do.
I'm working on it.
You're not working on it. It'll take you 42 years to get this place in the shape that it needs to be. At the pace that you're operating.
I'll work days.
Listen, I don't care if you have to hire contractors. The place is a dump.
tried to get help. I've tried to hire
Mr.
help.
Boyd,
Nobody wants to work. Willing to pay them $10 an hour a day.
$10 an hour. No wonder they're not willing to work.
Well, I make minimum wage. I work for it.
You're not gonna find anybody to come over there and deal with that mess for $10 an hour.
Well, they have to work with me, but it's,
Where do you work?
I work for, Motor City Solutions. I'm a test driver for Ford products.
This is just, this one request in your, did you send this to Mr. Boyd?
I did, Your Honor.
You got winter boat storage is only permitted on residential waterfront surfaces pursuant to your code 13.09.
Right, that's just to ensure that the boat doesn't remain there over the winter.
It's a dangerous structure to begin with.
Yes, sir, they've done a number on it.
Who's they? Who parked the vehicles there? Who parked the boat there? Who let the garage go to the point that it's dilapidated and needs to be taken down? Come on.
They tore it up.
I don't know what you're saying. You told me this when I was out there. I don't want to hear it at this point.
I mean, you saw the windows were knocked out of it. You saw the door was tore off. I didn't do that. The door tore off my tool trailer. I'm missing.
I have a feeling once I order this, you're not going to do anything.
I work on it every day I can.
Come on.
Really?
No, you don't. No, I don't believe you. You're not being truthful.
I am being truthful. It's rained a lot of days.
You told me that too.
Yes, sir. It's rained a lot this week. It's gonna rain today.
Is it? Okay, Sonny Elliott.
Pardon?
It rained Sunday, right? Or Monday? Did it rain Sunday?
Rain Monday.
I know. Did it rain Sunday? No. Did it rain Saturday? No.
Yeah, it did.
Did it rain Saturday? I wasn't here. Some,
It's rained a lot.
Mr. Boyd,
Saturday, we had, all them big thunderstorms come through.
all right. Listen, I've heard enough. I don't want to hear any more excuses.
Can't help the rain.
Mr. Boyd, I don't want to hear it.
Give me more time and Rob can keep an eye on me. I'll work on whatever he wants me to work on first.
Anything else? Anything else?
No, sir.
Anything else?
No, Your Honor, the people will just rely on since it's not random.
Do you have any objection to any of these items that they're requesting in their sentencing memorandum?
Pardon?
They sent you this sentencing memorandum. Did you
Oh,
read it?
yeah. I saw that.
Did you read it?
Yeah, I got that on Monday.
Okay. Do you have any objection to following all these rules?
Yeah, as best I understand them, yes.
Listen to my question. Do you have an objection to complying with all these items that they're asking me to order?
No.
I don't know how in the world. I'm gonna talk about a mechanism for timeliness. And I gotta tell you, I don't want to hear any more about the rain. Okay? That is just six months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. I'm not going to copy all of this. I'm going to put it in an order. Amy, you can tell probation. Here are the conditions. All vehicles parked on the property must be located on a concrete or asphalt driveway surface. They have to be licensed.
I have a stone drive.
Stop, I don't want to hear it. I'm going to tell you what, I'm telling you, it has to be on a concrete or asphalt surface. It has to be licensed, and the vehicles have to be operable. Any vehicles that are not operable have to be stored inside an enclosed building or removed from the property. I don't think you have an enclosed building that's going to accommodate all the vehicles you have there. So you got to get them off the property if they're inoperable. Any recreational vehicles such as your boat, anything else must be operable, licensed, and registered to you or the occupant of the property. You have to have any recreational vehicle stored on a hard or pervious concrete, asphalt, permeable, grass pavers, or gravel surface. They must be used for their intended purpose and not as storage. So you can't just have a boat in there and throw a bunch of junk in there. All non-permitted accessory structures have to be removed. You do not live on a residential waterfront surface, so winter boat storage will not be permitted on that property. The garage must be torn down and removed, and any excavation thereunder filled to grade level. Did I sufficiently cover that one? I think I did.
I think so, yeah.
Junk, trash, rubbish, tarps, anything that creates rodent harborage or refuse of any kind needs to be removed. Okay?
Okay,
Junk includes parts of machinery or motor vehicles, unused stoves or other appliances stored in the open, remnants of wood, metal, or any other material or other cast-off material of any kind. Weeds, grass, and undergrowth must be cut and maintained so as not to be higher than 8 inches pursuant to ordinance. You are to allow township officials on your property for a compliance inspection, at least weekly or more. Now, I want to know about a timetable here. This is only 6 months and I want this done quickly. Sir, you seem like a nice man, but you cannot have that kind of junkyard in the middle of the township. You can't. Well, I know you say you understand, but you're not moving. You gotta move.
I feel like I have to move. I don't have a whole lot of time after work, I get.
I don't know what to tell you. That property did not reach that level of sloppiness, junkness, whatever you want to call it, overnight. I would have to say it's taken years. You gotta move. Now,
Sure.
Tabitha, type up everything on there, and you're gonna attach it to this. Now, let's set timetables. Do you guys have any ideas? Can you help me with this? What do you want out of there first?
Probably garage.
Yeah, the road and harborage and that type of stuff is probably the biggest hindrance or, the biggest complaint from the township is the road and harborage, which includes trailers and the garage. I mean, there's trailers that we didn't even see that, behind in the brush.
Why don't you get your sons to help you?
Pardon?
Why don't you get your sons to help you? You said you had 2 sons last time, did you not?
He's working 7 days a week, 12 hours a day. My other son works up the other side of 15 Mile Road.
How are you gonna get the garage torn down?
That's my main goal to go.
Well, I need it done now. How long is it gonna take you?
I don't know, I gotta see about getting a junk trailer and,
Well, I know, but I want a timetable.
well,
I'm giving it until September 1st to have the garage removed.
how about Christmas?
No. Christmas,
Might have to end up doing it myself.
sir. I don't think you're understanding. Christmas. This is the problem, you're procrastinating. September 15th, I want it down. We're setting a review hearing date, Amy. I need a review hearing date, garage to be removed by September 15th. I don't care how you do it, who you hire, who helps you, who doesn't help you. I want it done by then. I'm not going to worry about the excavation levels at that point, but by September 15th, give me a review hearing date, please, right on my first docket day after September 15th with Brownstown.
September 24th at 8:30.
Did she say December?
September.
December?
And then when you come in at the time, now I'm not saying you shouldn't be working on other things either. But I want that garage down by September 15th. So you're going to put that in the order. All vehicles. How are you going to do this? How are you going to do this? You're going to have to get rid of those vehicles.
I'll find out this morning.
Order, you include this, order pertaining to vehicles must be complied with by October 1st. Do you understand?
Sure.
We'll send you this order. You're going to pay fines of $200, costs of $100, 75 victims' rights fee, $50 justice assessment. I'm not looking at making you go broke here. $545 is your total, including its probation fees. We're going to give them a review hearing date in 6 months also. So prosecutorial review hearing date will take place should be mid-January.
January 14th.
January 14th, 26 at 8:30. I cannot repeat enough. I think you're a very nice man. So I want to print out a review hearing for September 24 at 8:30. Review date, January 14 at 26 at 8:30. And John, when you go over probation, I want them to schedule an appointment for him to come and see them because I have to type up this order. Okay? Anything else you want me to do or asking me to do?
No, Your Honor, I think this is fine for Mr. Boyd.
I'm just going to give you until January 1st to pay all your fines. Okay? Actually, I'm going to make it December 20th of 25. You have to pay all your fines by then. You go down, get your printed notices. You're going to go over to probation. They'll tell you when you have to come back. I have to have an order typed up. I need to file that.
Your Honor, when I with my job, I have to deliver cars to Ohio and
Yeah, you could, I told you at the time of the bond, but thank you for bringing that up. You can leave the state for employment purposes, okay?
thank you.
You can leave state for employment purposes. Now, I want to make sure that you're not going to go out of here, leave this building, and forget about everything I just said.
No, sir. I have that paper at home.
Okay, let's get started. Good luck. If you violate, like your status could 771, I'm taking this under 771.1. Case will be dismissed if you're compliant. If you're not, conviction will enter and you're subject to a 90-day jail term. Do you understand that?
Yes, sir.
You're not going to make me do that, are you?
I hope not.
Well, I don't want there to be hopes. You got to get moving, sir. I've heard enough about rain. Good luck.
Thank you.
Joshua Jordan Lazarick,
Ready.
255-415-022. Good morning, Mr. Bulahanis.
Good morning, Your Honor. May it please the court, Greg Bulahanis, P36431, on behalf of Mr. Lazare.
Mr. Lazarick, your name, sir?
Joshua Jordan, Lazarus.
Lazarick, okay. All right, so for purposes of arraignment, does he stand mute and wait for him?
Yes, Your Honor.
So I will enter a not guilty plea, and now there's going to be a plea to operating while impaired. I actually have a B file, another file, I should say, 25002, ticket number I-415.
Is completely responsible for the PDT refusal as well.
Right. Okay, so is that what you want to do, sir?
Yes, Your Honor.
You hesitated. You sure?
Yes.
If you plead guilty to operating while impaired and responsible to PBT refusal, I'm going to dismiss the operating while intoxicated on motion of the prosecutor. The possible penalties on this charge are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all those. 4 points will be added to your traffic record. Your license will be suspended or revoked in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes, Your Honor.
Okay. To the charge operating while visibly impaired, how do you plead?
I'm sorry, can you say that again?
Sure. How do you plead to the charge of operating while visibly impaired?
Guilty.
On May 30 of 25 at 8:15 p.m., were you operating a motor vehicle on Meridian near Grosio Parkway in Grosio?
Yes.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes, mixed drinks and roughly around 5 or 6,
What kind of mixed drinks?
vodka and lemonade.
And was your ability to operate that vehicle impaired because of the consumption of the alcohol?
Yes.
In what way? Why were you pulled over by the police?
He was unable to maintain his lane.
Is that right? You were crossing the center line, is that true, or driving onto the over the fog line?
Yes, Your Honor.
And you think you did that at least in part because of your alcohol consumption?
Yes.
Was this a breathalyzer or a blood test?
Breathalyzer, Your Honor.
And what were the results?
0.21 and 0.22, I think.
And you so stipulate that was an accurate plea?
Yes, Your Honor.
Accurate reading for purposes of the plea?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
All right, I'm gonna accept your plea. I find it to be an accurate plea made voluntarily and understandingly. The plea is accepted. I'm going to dismiss the OWI and to the charge PBT refusal, responsible or not responsible.
Responsible.
Okay, I'll accept that plea. We're gonna defer the sentence on that. I'm gonna have it at the same time as I have the operating while impaired. I'm gonna give you a $1,000 personal bond. You don't have to post any money, but you cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I'm gonna order that you attend AANA at least twice a week, and that's gonna be in person. We're gonna give you a form. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you to evidence that you've been attending. So you want to make sure you get that signed. Don't lose it. Don't let your dog eat it. Anything else that I've heard over the last 30 years. Okay? Do you understand everything?
Yes, Your Honor.
Where does he work, counsel?
DTE, and he is attending counseling, Your Honor.
Bernie Ball.
No,
Okay.
he's suffering from depression. He has a counselor that has been seeing for the last couple of months. Is that correct, sir?
I've been seeing a therapist for the last couple of years. There's,
Okay.
roughly about 6 months after he moved, and then I got back in touch with him. I've been seeing him every other week. I also see some help through the VA.
Good. So you were in the service?
He's an honorably discharged after 9.5 years.
In what branch?
Right where you are.
Congratulations. Thank you for your service.
And
I mean that. My father was in the Marine Corps. He's a major, and I have the highest admiration for anybody in the military. So let's get you back on track. You can do this. We'll give you a sentence date, and I will have you, you're going to be screened and assessed today. You'll come back for sentencing, okay? Mr. Gulahanis, make sure you, if you don't have an AA verification sheet, grab one from my court officer when he returns here.
Yeah, we
Give me
can,
a sheet. Give me a sentence date, Lisa, or Amy, rather.
August 27th at 8:30.
If you, counsel?
1 second.
Sure.
I can't do it at 8:30.
Okay, we'll do another day. I don't need this.
We can do the 13th. I'm sorry, Judge.
I don't really need it to be on a Trenton day, or Rosio day rather. There's no restitution, or anything. There's no accident, so we can set whatever date. I can do a Monday if you want, whatever you want, Amy. Yeah, I work for you. Are you good the 13th?
Or the 14th.
Okay, hold on 1 second. 1 second. August 13th. The 13th, I have 2 cases. You said or the 14th?
Yeah, we can do the 14th.
August 14th is good.
Whoever has that phone's got to shut it off and get out of the courtroom.
Folks, you gotta take your phones out of here, please. We have signs all over the building.
Do you want that in person or Zoom?
I don't care, as long as you're in the same location.
Yeah, I'm always with my client.
Yeah, I don't care. If you want to do it in your office, I'm fine. She's with
At 8:30 a.m.
August 14th, 8:30.
Okay.
Okay?
Yeah, if we can do Zoom, that'd be great.
That's
Thank
fine.
you so much.
No
Aaron.
problem.
And then
Have a good day.
You want him to see the probation officer right now?
I do. You're going to be screened and assessed. You're going to fill out a questionnaire and be interviewed, okay?
Thank you so much, Ron.
Thank you. Good luck.
Thank you, Jeff. Have a great day.
You too. Thanks.
Appreciate it.
Mexico. Tyler James Mexico, 25B1487048 and B. Your name?
Tyler James Mexico.
So you're charged with possession of a concealed weapon and possession or use of a controlled substance. You have the right to a lawyer. Would you like one?
Yes, Your Honor.
I'll set you up with a lawyer. And then you also have another file here, 23R 513044. That is a Rockwood case. Is Rockwood here today, Amy?
No, Rockwood is not here. I think that was a warrant cancellation.
Yeah, we'll give that to the lawyer. Where you been? You're supposed to be here in 2023. What happened?
I honestly don't even remember that.
You know what the title of my book's gonna be? Don't tell the judge I forgot. Okay? And that's gonna be the title of my book. Go talk to a lawyer, then come on back in here, okay? See you back here in a few, Mr. Mexicott. Barnier. Brianna Ray Barnier, 25B148694, A and B. Your name? Is that your phone? Is that your phone or your mom's? Fraudulent schemes and contributing to delinquency of a minor. You have the right to a lawyer. Do you want one? I'll set you up with one, okay? Go out in the hallway, get your, you meet with the lawyer will meet with the prosecutor, and we'll go from there. Tabitha. Don't forget to type that as soon as we get off. Okay. Thanks. Melnowski. Joel Dean Melnowski, file number 25B148750. How you doing, Mr. Melnowski? Your name? You're charged with a super drunk violation, which is punishable by up to 6 months in jail. You have the right to a lawyer. Do you want one?
Please.
Okay, we'll set you up with an attorney. All right, good luck. Who are our lawyers today? Here's one for an attorney. Thanks.
Yep.
Do you have anything else down there? Morning, Mr. Teal.
Good morning,
Good morning,
Judge.
Mr. Gordon.
Good morning.
John Earl Davis, 25W8392000 A and B.
Good morning, Judge. Bianca to you on behalf of Mr. Davis, section 494.
John T. Davis.
All right, so we're gonna adjourn this one last time, right?
Yes, Judge.
Okay, I'll go ahead and adjourn it out a couple weeks, Lisa. I mean, Lisa's not here today, Amy.
Judge, could you do 30 days, only because he has to go.
How many does he have to clear?
Quite a few.
Where do you work? How's he gonna come up with all the
He's
money?
indicated to me that he has the money to pay everything, so he's just gonna.
I'll give you 4 weeks. Don't ask again, though, okay? All right, give me, give me 4 weeks out, Amy.
September 3rd at 9 o'clock.
I don't have one at the end of August.
Well, this is a Woodhaven case, it looks like, so
Okay, good enough. September 3rd at 9 a.m. Set for trial if not resolved. Listen, if it's not resolved, then I'm gonna have to set it for trial. Do you understand that? So I'm giving you about 5 weeks, so you go take care of that, all right?
Okay.
All right, any questions? Go right down the hall, we'll give you a notice. Good luck. September 3rd, 9 o'clock. Randy Allen Tedora,
Thank you,
25B. Thank you. 148572.
Good morning, Judge Simpson, on behalf of Mr. Fedora, state your name for the court.
Randy Tadora.
All right, I need a order. Mr. Tedora pled guilty of open house party. The agreement was that it would be taken under section 771.1, with length of time to be in the court's discretion. Today's the date scheduled for sentencing. Anything you would like to say?
Yeah, sure. Mr. Fedora has been employed at Ford Motor Company for 29 years, and he has indicated to me that he is able to pay the fines and costs today.
Okay, anything else?
No, Your Honor.
Mr. Tedora, why were you doing this, Mr. Tedora?
It was a bad day on May 10th.
I'm sorry?
It was just a bad day on May 10th.
I know, but you had 50 kids that were drinking at your house. What if one of them gets
It only
drunk?
happened 10 minutes. I mean, it was not a party that I had 35 people show up in 10 minutes. And not one of them knew who I was.
Some teenagers had a notification set, and I don't know,
You don't authorize your kids to have parties, drinking parties at your house with minors, do
No,
you?
that's not how it happened. I
Well,
mean, I had 30 kids on my sidewalk and not one of them knew who I was or anybody in
Did
the
you
house.
tell them, you better get out of my house, you're drinking, it's,
Yes, they looked at me and didn't know who I was and was the rudest people I've ever met. And they were exactly the same way to the police officer. He lined them up on all my sidewalk and not one of them was from Woodhaven and not one of them knew who any of us was in the house.
well, if they're rude people,
They were coming through the backyard, they were jumping fences. There were 3 cars with 35 people in them. It all happened. I mean, if it was a party for 2 hours, I would have had the cops called a long time ago. I mean, it was just shocking, all seriously.
your kids invited some people over.
All 30 of those people didn't even know who my kids were. Didn't know anybody from the party.
You mean they all just decided we're gonna go up and drink at this house with nobody inviting them? They were in there illegally? Come on.
They came in through the side, they came in through the
I
back.
know, but
had-
somebody invited them, whether your kids invited 4 kids or 2 kids or 20 kids or 30 kids, somebody invited those kids over there. They didn't
According
just,
to the police report showed that none of those kids knew who we were or had the address. They showed up to a friend's location, but none of them, they were lined up on my sidewalk. One person from Woodhaven, and
they were hiding in the back room, according to the police report.
yeah,
You had bottles of vodka in there. They were playing beer pong. Somebody let the kids in. They didn't break into the house and start playing beer pong and bring bottles of vodka with them. Now, listen, don't make this worse than it is.
I know,
Somebody needed to call the police if they were breaking into their house, right?
they did, the cops came 5 minutes after.
Did you call the police?
The girl that was in my
Did
house.
you call the police?
My next door neighbor called the police.
Ah,
I was trying to.
did your kids call the police?
They were in shock. They didn't know any of these people. They didn't know any of these people. I mean, I can't believe that you're saying that you don't know what 17 and 18-year-old kids are doing nowadays. They don't care.
Mr.
They
Tedora,
don't care.
Mr. Tedora.
Yeah, all right,
I could tell you stories that you wouldn't even comprehend.
I get it, I'm learning now.
Don't tell me that I don't know what's going on out there, but your story does not make sense. That 30 to 50 people just started congregating in your house without permission, without your knowledge, without your kids' knowledge, and they're playing ping pong, beer pong, and having bottles of vodka. I'm not, you're making it kind of worse for yourself because you're not accepting any
I
responsibility.
accepted all the responsibility. I'm just telling you what happened.
You keep interrupting me, so that isn't good. 6 months probation under 771.1. You cannot leave the state without the consent of the court. You cannot violate any law. You change your address, place from employment or home telephone number, you must notify probation. You have to report as directed. I'm going to order that you serve 2 days of community service. You have to have that complete by September the 10th. Okay? 16 hours community service by September the 10th. You're going to pay $100 in fines, $100 in costs, $75 victim's rights fee, $50 justice assessment, $120 in probation fees, $40 in attorney fees. Everything included here amounts to $485. If you violate, your probation could be revoked. You could be incarcerated for 90 days. If you're compliant, at the end of 6 months, you come back. I'll be more than happy to dismiss this case on motion of the prosecutor. We're going to give you a review hearing date. You're going to go down the hall, pay your fines. Then you're going to go over to probation where they will instruct you. Do you understand everything?
Yes.
All right. Give me a date in mid-January.
January 14th.
At 8:30 in the morning, sir. January 14th at 8:30 in the morning. You come back. If you're compliant, the case will be dismissed. Do you understand all that?
Yes.
All right. Any questions at all, Ms. Patillo?
No, Your Honor.
Do you have any questions, sir? All right. Probation will instruct you. Go down, pay your fines, pick up your notice, don't lose it, and then go meet with probation. Best of luck. Thank you.
Thank you, Judge.
I'm gonna real quick take this one. Don't go anywhere though. Stevens Disposal and Recycle, 25B148990 A and B. Your appearance?
Yes, good morning, Your Honor. Jeff Osmond on behalf of Stevens Disposal.
I don't see where she took any action. Can you call her in, please? You're going to plead responsible to overweight. You're authorized to enter into that plea on behalf of the company with agreed upon fines and costs of $2,000. True?
Yes, Your Honor.
What did she do with the other one? She doesn't have any,
The other one, the defective equipment was, I believe, was going to be dismissed, and we did the overweight for 2,000, and I was going to ask for 30 days to pay.
okay, let me just get her in here real quick. Your name? You didn't take any action. You didn't write down. Are you dismissing the defective equipment? Would you write that on the stip form, please? To the charge of overweight, Mr. Osmond, responsible or not responsible on behalf of the company?
Responsible.
Plea is accepted, $2,000, paid by August the 30. I'm dismissing on motion of the prosecutor the defective equipment. Okay?
Thank you, Your Honor. Have a good day.
You too. Thanks a lot. Okay. Mackenzie Goff. Mackenzie Lynn Goff, 25B148638. This is A and C.
Good morning, Judge. Deanna Patillo on behalf of Mr. Cedric Simpson for the court.
Oh, wait a minute. You gotta go. Okay, you gotta go a lot louder than that. Can I have the victims up here, please? Come on up. How old are you?
16.
Go off the YouTube.
Stand right over there.
Such a conflict were to arise, we would move to waive that.
Thank you.
And Your Honor, we, from the Assistant Public Defender, Chinazi Kyriaki-Ridley, representing Mr. Jerome Burns in this matter, we also do not believe that there is a conflict in this matter, and if such conflict should arise, we waive that as well.
All right, very good. Can we get him out? Court does call the case of People State of Michigan versus Jerome Burns.
Good morning, Your Honor. Marie Penthouse, Assistant Prosecuting Attorney, on behalf of the people. And good morning again, Your Honor. Assistant Public Defender Chinazi Carey Akinruli, on behalf of Mr. Jerome Burns. Mr. Burns, state your name for the record, please.
Number. All right, are we ready to?
Your Honor, a few things. I've been communicating with defense counsel. We have witnesses here. Victim is on her way. Sergeant Matthews is driving her. I believe they hit some traffic, but we have our other witnesses present and ready. I did want to make a record. We received a great deal of evidence from defendant's phone. As the board likely remembers, we had a preliminary, an extraction. I shared that with defense counsel because it was of potentially exculpatory nature. I was also though very clear that's a preliminary finding. There was ongoing extractions from the phone and analysis that needed to be done. I was initially sent 2 zip files of what was extracted from the phone. Background to this is that there was at least one hidden folder in the defendant's iPhone that had biometrics associated with it. So essentially they could get into the phone, but they weren't able to get into the hidden folder. So we were looking at options for that. The extraction we received didn't work on any of the county computers, so I was unable to, yes. Ironically, I was unable to pull that up. I had informed defense counsel of having that, but also that I wasn't able to open it. So the next step was asking them, hey, is there another way we could do this where I could actually view this evidence and share it with counsel? I believe it was yesterday. And I will say Sergeant Matthews went above and beyond in trying to do things quickly. He was able to get 2 thumb drives, one for prosecution, one for defense, copied over to our office. I notified defense counsel. I believe they have picked it up since and are in possession of their copy. But it's a lot of information, Your Honor. And a lot of the information relates not only to the preliminary report that I shared with counsel, and in essence, it gives a lot more context than what I have been able to view, give context to that first piece of evidence. It's also evidence that we would want to ask the victim about. So the potentially exculpatory information, I believe, would necessitate the victim testifying again, unfortunately, given that evidence, but also the evidence that we are just recently in possession of would speak to that very closely. And I can go into further details at court.
I just want to make sure I'm understanding. So there's evidence that may be exculpatory, which would require the victim to reappear and testify.
Correct, Your Honor, to give context to that piece of evidence, but we also now the evidence that we have received as of yesterday, it gives a greater context to that preliminary piece that we shared with defense.
Got it.
The reason for sharing that first is because of the potentially exculpatory nature. I wanted to make sure they had it and they were ready. But of course, there's a lot more to it. And what we have other witnesses, I'm ready to continue with those witnesses so that they don't have to keep reappearing. But I'm not sure I'm comfortable proceeding with the victim's testimony until both sides have had a chance to review this additional evidence off defendant's phone. As I stated, victim is on her way here. She does have a son. I don't know if she was able to get childcare for him or he'll be with her. So I don't believe we reached a consensus this morning, but I did speak to counsel about, for her testimony, do we need to keep her here and take that testimony today? As I stated, and I'll say it again for the record, I'm not comfortable until both sides have looked at the evidence. I'm not comfortable directing her on it, and I'll leave up to counsel how she feels about cross-examining without those pieces. But as for the other witnesses, Your Honor, we will be ready.
Your Honor, we find ourselves in a pretty difficult situation because we have not been able to review all of the information from the thumb drive. I asked sister counsel, she's unaware because she hasn't gone through it either, if any of the information in the thumb drive may pertain to the witnesses that are present now and ready to have testimony taken from them. I don't see why there would be. However, there was some information just in the preliminary pieces that were sent over last week or a few weeks back that may have occurred around the time of the interaction with one or maybe all three of the witnesses present today, specifically some communication between my client and the complaining witness. We're not sure who was around at that time, but I just don't know what else is in the phone. There's a great deal. I am not experienced in sieving through this type of data. I'm literally just clicking on every folder or file and.
I thought you worked for the NSA. No, I'm sorry, go ahead.
Not on the right. In my prior life.
Yeah, okay.
So, and that's why I find it difficult to say, yes, I'm ready to proceed on the three witnesses that we have. Yes, I'm okay with an adjournment of, the information from the complaining witness. And I know my client's position 100%. He has been in custody throughout this entire period. He is very eager to resolve this matter. We received some very disturbing news from his family yesterday. His father's currently in the hospital, and he's been really struggling to assist with his mom. But I know that my conversations with him have always pulled out his desire to move forward and continue this case along. So we're really at a crossroads right now, Judge.
Right, and just so that we're clear, part of the reason the court agreed to adjourn the matter was because my understanding was the defendant believed that there was something that was exculpatory on the phone. And so that's why we even started down this path. Just that there, I'm not blaming anybody, it just is what it is. With reference to, I'm sorry, Ms. Eckenroley, were you done?
Sorry.
Okay, no, I just wanted to make sure. With reference to, you said you had three witnesses today.
We have three witnesses, Your Honor. Two of them are in the gallery. One is the officer who responded. The other one is a social worker who spoke to the victim at the time at the hospital after the assault.
So
They would be ready. We also do have Sergeant Matthews. Sergeant Matthews would be able to start today. We may want to recall him after the victim's testimony, depending, but he'd be the third witness that could start testifying today.
got it.
And I share defense counsel's lack of knowledge of technical things. So when she asked me about the messages, I was able to get through some of them. Of course, not all of it. It is a great deal of evidence. And I would agree that there are text messages, and those we do have timestamps, and Sergeant Matthews could speak to from defendant's phone, defendant messaging victim around the time that it seemed it was becoming clear to him that there might be some police involvement and things like that. I'm not sure if that affects Officer Morton's testimony. I mean, he responded, he did what he did, but I'll leave that.
Well, I guess I initially, let's take out, there's a social worker to testify who, and this may be the more difficult one for the court to try to analyze, and maybe part of the defendant's point, that
It wasn't me.
oh, you don't care? You don't care? No, man, I feel, that thing goes off, nothing. Then that goes off, nothing. No. You got me? Okay, thank you. No, don't worry about it. I feel safe. So with reference to the social worker who spoke to the victim afterwards, I would have to say I might be a little bit concerned if there are concerns with what the victim has testified to, and the victim is relaying certain information to the social worker, I'm not sure maybe the parties can clarify it if they can, or I don't know. It would seem to me that getting through or understanding what's on the phone is also going to be cloaked in that same context as the victim. If that made any sense.
It did make sense, Your Honor, and I'm racking my brain as to with the preliminary information we have, my concern, defense counsel might disagree, my concern isn't necessarily what the victim said. Our understanding of the evidence, especially with the little of the new evidence I've reviewed, is that the potentially exculpatory evidence, our perspective is that it's not exculpatory because there's a greater context and we have theories and so on. And I think that evidence will highlight that. However, again, like I said, defense counsel might disagree.
Well, and I guess my point to that might be, she might disagree or may not know.
Correct.
Which may be worse.
Yes, Your Honor.
Because it's that greater context, I guess, piece of of that evidence that might not only have some greater context to what the victim says, but might also have greater context to what the victim said to the social worker and what the social worker said.
I understand.
Is that sort of what you're referring to, Ms. Akin?
That's correct, Your Honor. But yes, not knowing what's on the phone, I don't know how it pertains to our social worker or even the officers, because again, there's, from the preliminary information, there were some communications that fell within that timestamp of after the event, during the time that other parties began to get involved. I don't know. And we just know that from the preliminary.
And you know, the difference between the preliminary, other than the obvious difference, the preliminary information we're able to get evidence about the time stamps, because in part of that report, and part of the supplement, I believe, Sergeant Matthews outlines this time, this day, this text was sent, and so on. With the new evidence, I don't have a way of knowing the timestamps on it, and the defense does either. So we would need someone to testify to all of that. And I don't know if Sergeant Matthews has had a chance to review all of it, because he similarly had a problem opening the initial file and has only since yesterday had access to all the information off the phone.
And Judge, I just wanna, I guess I need to just put this on the record. I know that I think it's important that the court notes that my client never requested for the people to get his phone. My client never requested.
Right. I mean, I agree with that piece, but and I'll certainly let you finish. What my point was, the defendant, at least as I was informed, the defendant wanted his phone, which he believed to be in his property.
Correct.
That his reason for that is because there was a belief that there may be something that might be exculpatory on the phone.
Correct.
Okay. When the defendant was, or at least the court was aware that he wanted the phone, I was then informed that the police agency had picked up his phone and had his phone. So if anything, I'm saying in terms of the request that it was the defendant who was requesting the police go through his phone, I don't think that's not what I meant to say. What I meant to say is it transpired that way because there was something there. The people, to their credit, then said, if there is something that is exculpatory, then we want to make sure that the defendant has that. So that might be a clear picture, but I'll let you go ahead.
Sure. Yeah, so that is correct, Your Honor, but I think the piece that the court should probably also note is that the only reason that they picked up the phone was because my client was asking a family member to come and get his phone for him so that he could instruct us on how to get that evidence out of his phone. And the police department overheard that call and then took it upon themselves to come and pick the phone up. And then that's where we got into this entire delay, because there was negotiations as to how we were going to get it to the phone, and things of that nature. So it does not change where we are. I just felt that it was important to clarify the record to that point.
And please understand that I wasn't trying to, and I think I may have said it at the end of my first statement, I'm not trying to blame anybody for the delay. I'm not trying to say the defendant is trying to delay this out or the people. It is what it is. I just wanted it that we, and I'll take you at your word for how or why they picked up the phone. But suffice it to say that somehow or another, that train started rolling down the tracks.
Correct.
And so
Absolutely.
we all had to deal with it. So.
If I could just add one thing, and it's simple for the record, because I know everybody here is aware of this. When we were here and there was information from the defendant that he wanted potential exculpatory things off his phone, I want to be clear, it wasn't a PCC. We were here for exam. The victim was here. People were ready to go. What I want to add to that is that the defendant also has a bond violation, and I know he hasn't been sentenced on that bond violation, and I'm not sure what the sentence would be. But this is there are many factors that go into this, and that is one of them. And the violation is such that it's not just a minor technical violation, it's quite a serious one.
So I guess the defendant wants to proceed right away, and I get everything that counsel has stated, but I'm worried, Ms. Eckenroley, that you'd be placed in a position of attempting to try to cross-examine a witness for your client's benefit, where you don't have benefit of everything. And that really is fundamentally my big concern.
Your Honor, I'd say the people share that concern, and in communications with counsel, I also want to be clear that if we don't continue today, that is not from the people not being ready. That is not from the people saying we don't want to continue. In fact, as I stated, the victim is on her way despite many difficulties to try to make it here, and our witnesses are present. So for as much as it helps to the defendant's benefit, this is us also trying to be very careful in how we go about things. None of us want there to be issues on appeal. We all want to make sure that we're very careful and respecting not only the rights of the victim and the people, but really the rights of the defendant.
Right. Ms. Eckenroley, have you had a detailed conversation with your client about going forward today? I mean, I realize that some of the issues that the court is raising, you may not have because I've raised those, but you're smarter than I am, so you may already thought about that.
And Judge, I mean, if the court is okay with giving me a moment to, now that he's been able to sit here and listen to all sides of it, yeah.
And I'm not going to have a problem with that. Let me, what I've said about the social worker, does either party see with reference to the two officers that same potential issue arising?
Your Honor, it comes down to what Your Honor very eloquently put. We don't necessarily know. I don't have reason to believe. There's nothing I've seen up until now that would suggest that. There's of the things I've seen, there's nothing that would make me think that we couldn't proceed with the officer's testimony. But
I'm sorry, I don't mean to interrupt, but the officer spoke with the victim.
correct, yes.
Correct.
Yes.
And from speaking with the victim, a report, that's part of the report, right?
Yes, Your Honor. So there was an interview with the victim. There was an interview, of course, with the social worker who had spoken to the victim. And there was at least one interview with the defendant.
Okay. I mean, just, and I haven't had a chance to necessarily think that entirely through, but it would seem to me, oh my goodness.
Instant smile, Your Honor. Just making sure we're doing our
I can
jobs.
hang
just
out for
right.
a little while for the court's next recess.
Well, I'm out. All right. It is so good to see you.
Thank you. Good to be seen.
I'm happy now. Despite your, despite your non-attention to my safety. I'm happy. What? So, let me just put it in a nutshell. It would seem to me, and maybe this would be the conversation that needs to be had, that anyone who spoke with the victim is going to fall, in my mind, into that same potential concern regarding placing context around what her statements are. I think we're in the same boat. I picked the social worker initially because it was going to be difficult, but there was also going to be a closer conversation between the victim and the social worker. But I think if the officer interviewed the victim, that same thing is going to happen or potentially happen. In a sense.
Your Honor, may we approach just briefly?
Well, no, this is where it starts. You know, I'm going to just tell you, I walked in here, two of my favorite attorneys, and I said, this is going to be a good day to come back from vacation. You have both ruined that. You may have ruined. Record should reflect we've had a branch conference in this case. I'm going to give counsel time to talk to the defendant in this case. So the court's going to stand in recess. That can only take as much time as you need.
Yeah.
All right.
They're going to dismiss 11B 65206, 23B 814-381, and they're also going to dismiss 11B 65205, and then he's going to plead on 24B 82280, and he's going to have to pay the show cause amounts on the two civil infractions. He's going to be able to pay that today, right?
I don't know if he'll be able to pay that today, Your Honor, just due to his financial situation and his disability, Your Honor.
Mr. Farrell,
Yes.
what do you think a judge would think about somebody who hasn't taken care of a 2011 case?
Sir, I was not notified. I moved out 2015 and there was no notifications. I had the same problem when Paul Mendel was the agent for the township too.
All right, so he's gonna plead guilty with the plea to be under 7.7 and 1.1 for 3 months, right?
That is correct, Your Honor, with the conditions for him to finish cleaning.
Comply with all township ordinances and permit township officials entry for compliance inspection, right?
Correct, Your Honor.
All right, sir, is that what you want to do?
Yes.
If you plead guilty here, that's, I'll take it under section 771.1 for 3 months. The possible penalties are up to 500 fines, 90 days jail, costs are all those. I'll set terms and conditions. If you're compliant, the case will be dismissed at the end of 3 months. Also, as part of this agreement, I'm going to dismiss those 3 cases we just talked about. And then you're going to have to deal with the show causes on 23B 76671 and 23B 82267. It looks like you owe 207 and 213 respectively for a total of 420 on those. Do you understand everything I just said?
Yes, I do.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right to question their witnesses, bring in your own, use the subpoena powers of court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes.
All right, hand me an order, please, probation order. All right. Do you have any questions before I ask you how you plead, sir?
Not really, just, you know, how can I comply with something when I've not been notified of it?
Well, you can comply now. Now you know, right?
Well, yeah, but you know.
Donnelly, sir?
Mr. Farrell.
Hang on a second. Do you live on Donnelly?
No, I own the property on Donnelly. I live in Adrian.
Well, look, I don't know what to tell you. I mean,
well, how can you comply with something when you're not knowledgeable of it?
Mr. Farrell,
Yes, sir.
let me let you in on a secret. I'm just the impartial arbiter here. I'm not about to engage in an argument with you.
Okay, I don't want to argue.
Well, you kind of do. You want to argue. How can I comply with something if I don't know? I don't know what to tell you. They sent it to that address. Did you tell the township where you lived?
I changed my address with the post office.
Well, how long ago?
2015.
You think that's still in effect?
I don't know how long. I don't work for the post office. I don't know how long it works.
Well, if they sent it to your address and the postal forwarding is still going on, you should have received it, right?
Well, I have not received anything.
Well, then maybe you need to go back and you need to make another forwarding change with the post office. I don't know. I don't work for the postal service, okay? I don't know what to tell you.
I agree. I don't work for them either, but you know.
Do you want to keep arguing? So I'm going to pass this case and do it another day, or are we going to
Your
be
Honor,
able
if
to
I
take care
may
of this?
just have 5 seconds to speak with my client. Mr. Farrell, I had a conversation with
You seem
prior to going on the
cantankerous
record.
here, and I'm not gonna put up with that nonsense. If you want to come in here in person next time, we'll have this conversation face to face. I'm not gonna argue with you.
I just want to get this over with so I can move on.
Well, then don't start chirping at me, or I'm going to adjourn this, and you're gonna get to drive in here from Adrian or Timbuktu, wherever you are. You got it?
Yes.
Are you
Yes,
ready?
I'll take the guilty plea.
Are you ready to proceed, Mr. Farrell?
Yes.
Do you understand everything I've said so far?
Yes.
You understand if you plead guilty, we're not going to have a trial. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt.
Yes.
By the way, how did you find out about this case now?
I got a phone call from the township agent. He identified himself as a Brownstown Township police officer.
When did you receive that call?
That was back in January. He asked me, had I received his letters? I told him I have not received any letters. I didn't know anything, and he wouldn't identify what the letters were about, so I had no way of knowing.
Just so you know, if he called you back in January, you didn't show up on this case until you must have hired Mr. Bogard.
Well,
And
there was a Michigan State police officer
Mr.
delivered.
Farrell, please stop talking right now. Just let the judge talk. Stop interrupting.
There was a Michigan State police officer delivered a summons to the Brownstown home.
Mr. Farrell, stop talking.
Okay.
You understand all your rights?
Yes.
Understand you plead guilty, you're giving up all those rights?
Yes.
To the charge violation of the anti-blight ordinance, how do you plead?
Guilty.
Do you own the property at 22341 Donley in Brownstown Township?
Yes, I do.
Did you own the property there on March 19 of 24?
Yes.
Does anybody else occupy that residence?
My daughter.
And do you agree that as of that date that you violated the anti-blight ordinance as the owner of the property by allowing, or at least there was in the rear yard, piles of trash?
Not trash, sir. It was automotive, motors and transmissions.
All right. And do you agree that that was in violation of the ordinance that you're charged with?
I suppose so.
Mr. Farrell, it's yes or no. I'm not going to do this again.
Yes.
Stop arguing.
Did you say yes, sir?
Yes.
Anybody force you to plead guilty?
No.
You're not on probation or parole?
No.
I'm going to accept your plea to that charge. I'm going to dismiss 11B 65206, 23B 814381, 11B 65205. Do you have a good relationship with your daughter? I mean, if she got the letter that was addressed to you, wouldn't she have called you and said, hey, Dad, you got a letter here?
Yes, she would have.
So they just must have mailed it to Arkansas somewhere.
I don't know where.
Okay. All right. Well, okay. And part of this agreement is it's going to be taken under 771.1 so that if you comply with this, the case will be dismissed. You understand that, right?
Yes.
And you understand also the terms are that you have to comply with the township ordinances and permit township officials on the property for a compliance inspection?
Yes.
You agree to that?
Yes.
And you're going to advise your daughter of that, right?
Yes, I will. Are they going to contact me prior to showing up? So, you know, because she's got a big dog there and I don't want anybody getting hurt.
Let me call in Caitlin, please. Let's make sure of that. Good morning. Your name?
Caitlin Collier, Brownstown Township.
I'm ready to go ahead and sentence. He says he's got a big dog. He's requesting that before the officials enter the property that they call him. I'm going to have him give you his phone number now. And then you can coordinate whenever they're going to go out there, okay? Can you give that to her, sir?
Yes, 734-991-5130.
Thank you.
All right, so that's the way we'll do it. I'm ready for sentencing if you are.
Your Honor, I have no issues with sentencing. If I may accuse on behalf of Mr.
Sure.
Farrell briefly. Thank you, Your Honor. And Your Honor, my conversations with the prosecution here, obviously all interested parties are interested in having this property cleaned up. It's my understanding that the recommendation here was to have this taken under 7.1 for a period of 3 months to give Mr. Farrell the opportunity to continue to make improvements on that property. It's my understanding that Mr. Farrell, at the conclusion of this, would like to sell that property and be able to move on from this point. I did explain that to the prosecution. So he is going to be compliant with this probation status, also will be compliant with the city ordinances in order for him to be able to sell this property. The biggest thing here.
How long is it going to take?
To clean the property?
Yes.
It's my understanding a dumpster was delivered to that address here today, or is being delivered to that address here today in order for them to continue to finish.
So if I order him to do it by August 31, is that reasonable?
I would believe it would be reasonable, Your Honor. And the only reason why I say I believe is because he relies on his son to do it over the weekend. His son does work full time. Mr. Farrell is completely disabled. He did serve in the military. He is disabled partially from that. He is legally blind. He doesn't have the ability to do it himself. So everything has to either come from the help of family. It doesn't always happen, or he has to hire it out. Mr. Farrell is on a limited fixed income. So that is part of the issue with paying fines and costs. He doesn't have the ability to generate more income than what he gets on a monthly basis. And what he gets on a monthly basis is very limited. So Your Honor, I'm just asking the court to take that into consideration. I know this matter's been open for a while. I know that sometimes things are harder than it needs to be, but we are asking the court to take that into consideration so that way the property can be cleaned up, it can be sold, Mr. Farrell can make some money from it, and pay his fines and costs as well. He understands that things have to be paid, just doesn't have the ability to pay everything immediately or a large sum of money, Your Honor.
Okay. All right, Mr. Farrell, anything you would like to say?
No.
All right, I'm going to jump over to the civil infractions. This is 23B 76671. Yeah, I'm not even going to address it. I think he agrees he owes the money, right?
Right.
You're going to pay $75 per month beginning August 10th until that one's paid in full. And then you're going to pay on 23B 82267, $75 per month after fines and costs paid on 23B 76671. So you're going to pay on 7/1 first, 6/7/1 first. You're going to pay on 6/7 next. And then I'm just going to fine you $100, costs $100, 75 victims' rights fee, $50 justice assessment, 60 in probation fees, $385. I'm going to place you on probation for 3 months on this misdemeanor under 771. Properties to be cleaned up and in compliance with township ordinances by August 31 of this year. You're to comply with all township ordinances and permit township officials to enter the property for compliance inspection. So that's pretty simple. Again, you cannot leave the state without consent. You can't violate a law. You must appear in court as directed. We're going to give you a review hearing date. You have to report to probation as directed. I'm going to give you a review hearing date. You show up in 3 months. I will give you all the way until the day before the review hearing date. I'm questioning how he's going to pay all that, but he's going to have to figure out something, okay? What's a review hearing date on this in 3 months? Make it as long as you can. Like, do you have October 28th or something like that, Amy?
You've got October 22nd with Brownstown, or you could cross over on the 29th with Judge Husson.
October 29th of 25 at 8:30 will be your review hearing date. Okay, sir? I'm going to give you until October 27th to pay all of your fines on that case. So you owe $385. Maybe you can walk him through this. You pay that by October 27th. He has to pay that on the misdemeanor. And then I set up the payment plans of $75 per month on the other. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for appeal purposes. Do you understand that, sir?
Yes, I just don't know. I'm not going to be able to pay that much money. I don't have that.
Well, I'm going to have to extend probation then. I don't know what else to tell you. If you don't have the money on any one of these due dates, you call the court, we'll go on Zoom. I'll give you an extension, but I can't discharge you from probation and dismiss the case if you haven't paid your fines. If we need to make it longer, I'll do that.
It's just causing a severe financial hardship, sir.
I don't know what to tell you.
Well, Is there some way that, I can show that I cannot afford to pay this?
I'll extend the probation, sir. I mean, I went as light as I can go here. I mean, really, the $75 victims' rights and $50 justice assessment, that's mandatory by law. I went as light as I can. I can't go any better than this.
So what is the total on the fines?
You owe $385 on the misdemeanor, and you owe $207 and $213 on the civil infractions respectively.
All right, there's no way that I can meet that in that time frame.
Okay, you want me to extend your probation for a year? I can do that.
I'm struggling right now.
I'll tell you what, I'll make this probation 1 year. We'll make it 1 year, and I'll only charge him probation fees for 3 months. I'll do that. I know.
Your Honor, if he has the ability to pay it off or comes up with the money.
Yes, I'll discharge him.
Thank you, Your Honor.
Give me a new date before July of 25, Amy. 6 rather. 26. So I want to be clear about that. I will be glad to discharge you if you can come up with the money before then. I can't do better than this.
All right,
June 24th.
I'm sorry?
June 24th?
June 24th of 26 at 8:30 in the morning. If you said you're going to sell your house, if you're going to sell your house, you should have plenty of money to pay these.
That don't happen overnight though, sir.
I just gave you 10 months. I don't know what to tell you. You just want to argue with me.
No, I will.
Can I let you in on a secret? When they quadruple my salary, maybe, just maybe, I'll argue with people. I do not deserve to be argued with. I've maintained my patience with you. I'm not going to argue with you anymore. Do whatever you got to do, okay? If you need more time on these, you call the court. I'll be happy to go on Zoom with you and give you an extension. Best of luck. Thank you. People against Timothy Sean Walsh, 25B1486554A and B.
The total again? Total price?
Jesus. I don't know what to tell you. I told you 213 and 207 is 420 plus, what did I say? 360? 420 plus. $385. You owe $805. Good luck.
Okay. I'll do what I
Timothy
can.
Sean Walsh, 25B1486548 and B. Your name, sir?
Tim Walsh.
Okay, so you're going to plead to allow an unlicensed driver to drive and distracted driving causing an accident with the understanding that the driving on a suspended will be dismissed and improper lane use will be dismissed. True?
Yes, sir.
Okay, so the distracted, 0 points. The allowing an unlicensed driver to drive is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes.
You plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
Yes, sir.
To the charge, by the way, you have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No.
To the charge, allowing an unlicensed driver to drive, how do you plead?
Guilty.
On May 29 to 25, were you in control of a 1997 Ford that was being operated on Telegraph
Yes, sir.
in Brownstown? I can't hear you.
Yes.
And you were operating that vehicle and you knew you were suspended or revoked or denied. Is that true?
Correct.
Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No,
To the
sir.
charge, distracted driving, causing an accident, responsible or not responsible?
Responsible.
I'll accept that plea. I'll accept the plea to allow an unlicensed driver to drive. I'm going to dismiss the improper lane use and the driving on a suspended. Are you ready to be sentenced?
Yes, sir.
Anything you'd like to tell me? You have a valid license now?
No, sir.
You gotta go get one, okay?
Yes.
Anything else? You're revoked. Ugh. What are you driving on a revoked for?
It had a doctor.
Did you ever talk to a lawyer about trying to get your license back?
Yes, I'm in talks now. It just wasn't enough time from when you adjourned it till now.
I know, but you've had a drunk driving. Your last one was, am I right? 01?
Sounds about right.
Anything else? 100 fines, 125 costs, 75 victims' rights, $50 justice assessment. I mean, that's a little light, but I'll do that because you haven't had a issue in 23 or 4 years. 350 or 90 days, 195 on the distracted, 545. You can pay that today?
Yes, sir.
Go down the hall, take care of it. You're all set. Wish you well.
Thank you, Alan.
Is Timothy Shamus here?
Right here, sir.
Come on up here. 25B82610. This is People Against JTT Jefferson LLC.
Yes, sir.
Your name?
Timothy
What are you
Shamus.
doing? You're ignoring us like this?
No, it was a simple miscommunication between my business partner and I. I have no disrespect towards the court. I hold the court in highest regard.
We've had this scheduled 3 or 4 times.
Yeah, it was something that my business partner was taking care of. I wasn't really.
Well, you better get a new business partner. Tell them to be a lot more responsible when it comes to us.
The business has been sold since June 2nd was the last day.
Well, you need a lawyer. I can't give you a lawyer. That's the problem. It's an LLC and it's a misdemeanor. I cannot bend the rule on this.
Oh, really?
You're gonna need to get a lawyer
Okay.
quickly,
Like right now? Or,
like in the next week or so.
oh, okay, I can do that.
All right. So you're Mr. Shamus, right?
Correct,
SHAMMAS?
correct.
Amy, can you give me the earliest date? I mean, 2 weeks out for arraignment and pretrial,
August 13th.
August 13th. You can get a lawyer by then?
Yeah.
Look, I'm not gonna make an issue of this, but you better have a lawyer show up.
Okay.
August 13th at 9 a.m., okay?
Do I have to be present with the lawyer?
You do,
Okay, thank you.
okay? And then I'll dismiss your show cause if everybody shows up. Good luck. Heather Ann, go down the hall and get your notice, all right?
All right, thank you.
Heather Ann Drogash, 25B82690A and B and C. All right, what are we doing? Okay, we're gonna go ahead and, your name? Heather what? We're gonna adjourn this one to August the 13th at 9:15. Good, Amy?
Yes.
At 9:15. And they're gonna notify the complainant, you can come back then, okay? Best of luck. Joel Dean Malnofsky, 25B148750. Sir, you've been sitting back there all day. Do you have a case?
Yes,
What's your name?
Legacy, Steve Legacy.
Where's his file? Do you have a lawyer?
No, I'm just supposed to get out of probation today.
Who were you on probation? What city was that?
Brownstown.
Caitlin, do you have Steve Legacy's file? This poor guy's been sitting around here for an hour and a half at least. It sounds like it's just a review hearing. Can you hear me, Caitlin? Go in there and see if she's got it, John. All right, Joel Dean Malnavsky, 25B148750. Your name? How you doing, Mr. Crawford?
Good.
Your name?
Joel,
All right, so for purposes of arraignment,
I'd like to say, wait for more reasons.
not guilty pleas entered. And now there's going to be a plea from, it's actually a super drunk. Oh, so he's going to plead to operating while intoxicated, right?
He's gonna plead down to the lesser charge of operating intoxicated, correct?
And then the super drunk will be dismissed, true?
True.
Is that what you want to do, sir?
Yes, sir.
If you do that, the possible penalties are up to 500 fines, 93 days jail, 365 hours community service. Court costs are all 6 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, sir.
Did you sign, read, and understand the advice or rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
This says he's gonna apply to sobriety court?
It's,
He's got a prior?
yes,
Ooh, this isn't good. Is that right? You want to get into sobriety court?
Yeah.
You think you got a drinking problem?
Not really, I mean, I drink sporadically with friends.
Well, you had one 2 years ago, and now here you are again, and you got like a 2 or 3 on the breathalyzer or blood draw, right? I only want you in sobriety court if that's what you want to do. Be glad to help. You think you need help, but if you're going to tell me I don't have a problem, maybe you understand what I'm saying?
Yeah. I don't believe I have a problem, but I'm not sure what sobriety court is.
Okay. Well, I'm going to send you over to talk to them. I'm going to take your plea now. And I'm going to trust that you're going to want to do it. If you're not, I hate to tell you, you might end up in jail, okay?
Well, in that case, I'll just go ahead and do sobriety court, sir.
I don't want, okay. Do you understand the possible penalties that I outlined?
Yes,
Did you sign the advice of rights and read and understand it?
yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing nor a trial. Do you understand that?
Sir.
excuse me, Your Honor, just to be clear, the client's pleading no contest.
And the reason, I'm sorry, I didn't see that. It
It's
didn't.
lack of recollection.
Is that right, sir? Do you understand a no contest plea has the same effect as a guilty plea? Nice and loud for me. You got to keep your voice up.
Yes, sir.
All right, so, counsel, you stipulate I can utilize the police report to establish a factual basis?
Still stipulated.
Mark that one. And again, the same penalties that I outlined with you. It's just that it's a no contest plea instead of a guilty plea, and you understand that.
Yes, sir.
And you understand you're giving up all the rights on the advice of rights, correct?
Yes, sir.
All right. To the charge of operating while intoxicated, how do you plead?
Not guilty.
No contest, sir?
No contest, I'm sorry.
And you understand that's in effect a guilty plea, correct? Just, I'm not going to ask you questions.
Right.
You understand that?
Yes.
All right, so I'm going to ask you again, to the charge operating while intoxicated, how do you plead?
No contest.
I've had the report marked People's One, I'm going to review it. Ooh. Right in the beginning here. Hit 3 parked vehicles and rolled your vehicle. Now, I don't want to quarrel with you, sir, and I don't want to talk about this. But if you're running into parked cars and you just had one 2 years ago, I think you're understating the extent to which you have a problem. I'm not trying to make you feel bad. You need sobriety court. It's intensive. It'll change your life. It'll be very, very, very beneficial for you, but you got to embrace the program. Are you on probation or parole?
No, sir.
Anybody force you to plead no contest?
No, sir.
Plea is accepted. To OWI, I'm dismissing the super drunk. I'm gonna make a note. You're gonna get into sobriety court. If you don't, I'm not threatening you. I'm just telling you, I'm not doing my job if I don't send you to jail. I'm ordering a screening and assessment. You're going to have to go to the Brownstown Police Department. So what I'm doing is I'm giving you a $2,500 personal bond, but I want you to listen very carefully. And then, assuming sobriety court, you're going to follow the bond conditions that they outlined for you. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify the probation department. Again, you have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to attend AANA at least 4 times a week, and you have to go in person. Do you understand that? Yeah.
Your Honor, could we discuss that a little bit? My client doesn't have a vehicle anymore. He has no support. He's handicapped and he has one arm.
How's he going to get to sobriety court?
That was another situation we're struggling with. He's he's in a tough spot right now, doesn't have a lot of support.
He lives in Brownstown in the middle section. The middle section is not that far from here, is it? Pardon?
No.
Probably a mile, right?
Couple miles.
That much? Maybe, okay. All right, I won't make you go in person. You have to get a SoberLink device by the end of the day.
Well, Your Honor, I also want the court to know that my client understands that he's having some issues with alcohol right now. He is
Cullen,
already
Emily.
taking, he's already enrolled in AA program online, correct? Correct. And we were hoping that perhaps that could apply for his AA.
Yeah, I'll do, well, I'm gonna do the Zoom, I'll let him do it by Zoom. The AA, that's how he's doing it, right?
Yeah.
So you can do that 4 times a week. You have to be on a SoberLink device. You have to be on a SoberLink device by the end of the day. They're going to explain to you how to do that. You're gonna have to somehow get out to Livonia. Either that or I'm gonna order you in custody until they get a SoberLink device on you. And you don't want me to do that, sir. Because if I do that, honestly, you're gonna be sitting in jail for a couple days. You don't wanna be sitting in the Wayne County Jail. That's no fun.
Well, Your Honor, the client doesn't
And I
have a
am-
car, he doesn't have access to a car.
I can't resolve these problems other than saying, I'd have to set a bond and you're gonna end up sitting in the Wayne County Jail so they can fit you with a SoberLink. Did you get a hold of Emily?
Yes, she should be coming.
Emily, come on in here, will you please? This gentleman is in desperate need of sobriety, Corey. He doesn't have a car anymore.
Okay.
I'm ordering him, whether he gets in sobriety court or not, he doesn't know a lot about it, to be on a SoberLink device by the end of the day.
Okay.
Which mandates that he drive out to Livonia, right?
If you warn, but so
Can you get him one? Can somehow they get us one to give to him?
I have.
Perfect, that's what I was hoping.
Yeah.
That's perfect. I want you in sobriety court, Mr. Melnowski. He had one 2 years ago, Emily. Emily, he had one 2 years ago and he drove into 3 parked cars and rolled his car. He doesn't know if he's got a problem or not, is what he told me. We're gonna get this gentleman in here. We're gonna change his life. He's gonna stay with us, right?
Yes, sir.
Because you're gonna die. How old are you?
48.
I'm sorry, you do not work, right?
You're correct, I'm not permanently disabled.
He's got physical disabilities and mental disabilities. He's managing. That's why you might see in a report that they found some Xanax in his blood, but it's Xanax and related.
Okay, I didn't.
Well, that would be another thing if he wouldn't be able to be in sobriety court if that's. a
Right.
restriction.
See, we can't let him in with that. We could,
Usually we give people the opportunity to.
I know. That's what you're gonna do. You're gonna speak to your primary care physician. I want you to cover all this with Ms. Tessino. We can't have people in here that are on drugs like Xanax. Your doctor might say it's necessary that you be on that. Your doctor might say, we can give you some other drug that's fits our program. And we might still be able to get you in there, but we can't have people on certain drugs, of which one of which is Xanax. So what I want you to do is, we're gonna give him a sentence date.
So do you, I don't know, I'm thinking maybe we shouldn't start him on, we can give him SoberLink.
Right.
But maybe not start him on sobriety court bond conditions and give him
Until-
the opportunity to speak to the
Correct.
doctor. Okay.
Correct. So that's what we'll do. We're gonna put you on all these bond conditions, and then we're gonna tell you to go see your doctor. I'm gonna set this out about 5 weeks. You have to go get printed by the end of by 1 o'clock today. Do you understand that as well? Printed and photographed by 1 PM today, July 30. You have to get over to Brownstown. So I don't know how you got here, but however you did,
Do you want him to chemically test it all or just the SoberLink?
just the SoberLink right now. I don't think he has got a lot of money.
Okay, no, that's fine, yeah.
Give me a sentence date about 5 weeks out, if you would, Amy.
September 10th? At
Yeah.
8:30.
At 8:30, okay? So that's gonna be your sentence date. You're gonna go down the hall, get that. You're gonna go across the hall to probation. When you go to AA online, you have to at least talk every day. You're gonna have to type something saying, or write something saying, this is what was discussed. This is the meeting I attended. This is the ID, the Zoom ID, and this is what was discussed, and you're gonna write down the date. Okay? Do you understand? I can't just have you, I'm not gonna take your word. Yeah, I attended Zoom on such and such a date and such a date, and you're not telling me where and when and anything about what was discussed. Do you understand that?
I understand that, sir.
I didn't say mention names. I'm not asking you to mention names. It's anonymous. I get it.
Right. My big concern is that with my Xanax, I've been stable on it for 28 years, 27 years. And I'm not gonna be able to withdraw from that.
I'm gonna have you do these other bond conditions. We're gonna keep the sentence date in effect. Sir, you're gonna die if you don't do something. I don't know what it is. I mean, you're gonna die. You're telling me you don't even know if you have a drinking problem. You're rolling a car and driving into parked cars, my lord. So I don't know what to tell you. I'm still gonna encourage you to speak to your position because I don't know how else to put it. You can't. I'll sentence you on that date in September. Okay? Do you understand? All right. Anything else? Good luck. Mora Diego, Fernando, 7.
Judge, can I ask real quick who's in custody here? Sir, what's your name? Individual and county, what is your name?
William Easton.
Thank you.
Bench warrant. Good morning, Ms. Villarreal. Your name?
Good morning, Your Honor. Evelyn Villarreal, certified court interpreter.
I mean, so we get an interpreter, he doesn't show up. I said, okay. I'm gonna set a 5,000, 10% bond, court fines to attempt the adjudication, and you're free to go. Thanks, you too. Nice to see you as always. Legacy, Stephen Victor Legacy. I gotta get Brownstown in here. Can you come in here, Caitlin? Can you hear me? I need Caitlin in here. She can write this up. There's a review hearing for January 7th, 26. Mr. Legacy, I'm sending you to the prosecutor. She's gonna have to.
She's coming in here.
Your name, sir?
Stephen Victor Legacy.
How you doing? Prosecutor. Caitlin, your name, Foley Carter? Can you look at this? He's seeking early discharge. It's a 771 case. See if you're willing to dismiss now. Okay, go talk to the prosecutor. I'll wait right here. You've been waiting long. Our mistake. Good luck. Who else? What, did you meet with the prosecutor, sir?
No.
It's for what? Do I have a lawyer here?
I can get him on Zoom.
Who's the lawyer?
Dave.
Shows you that.
Oh, it's for her.
Yeah.
Did you meet with a lawyer yet today?
No, Judge, he just got in. He's scheduled for an arraignment pretrial.
Okay, so whoever our docket lawyer is, have them work on him right now because he's from the county. Give me that. People against a step. William Donovan, a step. 2OW82716 A and B. Your name?
William Donovan Easton.
All right, you have the right to a lawyer. You're charged with possession of drug paraphernalia from November 20 and retail fraud. from November 20 of 20. You have a right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No, I'm straight. I'll go and pray for it.
You charged with retail fraud on November 20 of 20. It is alleged that you did at 2380 Allen Road in Woodhaven at the Walmart commit the offense of retail fraud. That's one charge. That's 6-3A. On 6-3B, they think you were also in possession of drug paraphernalia. Both of those are misdemeanors. Both are punishable by up to 500 fines, 90 days jail. Costs or all of those penalties. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right to question their witnesses, bring in your own, use the subpoena powers in the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right. Now, do you still wish to waive your right to a lawyer?
Yes.
What are you in there for?
For, pleading and loading.
All right, I don't want you to tell me about the case. I just want to know where you are in the process. Are you awaiting trial?
Yeah. I just got arraigned the other day.
At the district court level?
No, at circuit court.
Okay, what's your bond on that case?
It's 280,000, I think.
$280,000?
Yeah, it just mad because I ran.
You got quite a record here. Aren't you getting sick of being in jail and
Yes.
running from the police?
Yeah.
My God. What are those cases out of Allen Park?
Yep.
All right. And Woodhaven is here today or not? Pardon?
They are here.
All right. I'm going to let you talk to the prosecutor and see if you can work something out, okay? I'm entering a not guilty plea on both of these. I'm giving you a $1,000 personal bond. No contact with prosecution. Witnesses, you're not to enter 2380 Allen Road in Woodhaven or any other Walmart. You're not to purchase, possess, or consume alcohol or illegal drugs. You can tell the prosecutor what you told me. We'll put him on Zoom with you in a breakout room, and you can see if you can resolve it. If you can't, and you want a lawyer, tell me then. I'll be glad to give you one. Do you understand that?
I'm okay. I'm okay.
All right, that's what we'll do. Thank you. People Against Legacy, Stephen Victor Legacy, 24B824, 28B. Your name?
Stephen Victor Legacy.
All right. Raise your right hand. You solemnly swear affirm under penalties of perjury. Testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
All right. I'm going to go ahead and ask you a couple questions. Since you were in court when I sentenced you, and I sentenced you back on January 15 of this year, have you been arrested?
No, Your Honor.
Any new cases pending?
No.
Any contact with the police for any reason?
No.
Prosecutor's good with this. Prosecutor moves to dismiss. You've been compliant. Case dismissed. I wish you well, sir. Sorry you had to sit here so long.
I'm retired, sir. I got nothing else to do.
Have a good day. Good luck. Thanks. Keep that dog under control, will you please?
I mean, it's kind of, kid put his arm in my door and got bit. It's not like the dog got out.
Okay, good luck.
He said he's retired. I wish I could say. But no. No, sleeping.
People Against Magyar, Christopher David Magyar, 25B145473, A and B. On this charge, we're going to issue a show cause on both of these cases. Defendant failed to appear for arraignment and pretrial. People Against Tackett, that is Scott Luke Tackett. 25B149006, A and B. Defendant failed to appear. We're going to issue a show cause on the A file, show cause on the B file. Defendant failed to appear. People Against Sanders, Darrell Levitt Standards, 25B148573. This is a destruction of property case. Defendant failed to appear. We will issue a show cause on that. William Martin Transport, 25B148008. Defendant failed to appear. We issued a show cause versus the company. President failed to appear. We're going to issue a warrant, 5,000, 10%. Amy, will you have somebody call over there to William Martin Transport in Belleville and tell him the judge is telling him to issue a warrant for his arrest? He better get his tail in here. People against Marlon Amir Owens, 25B149 007 A and B. 5,000, these are indecent exposure cases, and he didn't show up for arraignment and pretrial or the show cause. 5,000, 10% on each file. 5,000, 10% on each file. Warrant to issue. And I also have Matthew Glenn Malone, 25B14896. Defendant failed to appear. This is a trespass. 2,500, 10%. Failed to appear for arraignment and then failed to appear for show cause. So warrant to issue 2,500, 10%. Off.
Yes, sir.
Nobody told us. Sorry.
No worries.
How you doing?
Good, Your Honor. How are you?
Pretty good, thanks. Go ahead. Where's John at? Antonio Bailey.
Yes, Your Honor.
25F10960. Your name?
Officer McCardle.
Raise your right hand. Solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. You got to sign this complaint, though. You got to sign the complaint. You didn't sign the complaint.
Yes, Your Honor. I just signed it.
Did you send it over?
I haven't faxed it over yet. I'll have it faxed over right now.
All right, go ahead and proceed.
Okay. On 7/26/25 at approximately 02:28 hours, Officers McCardle, Porter, and Gatka were dispatched to 28811 Walnut Creek.
By the way, let me stop you a second. Nobody's in custody on this, right?
Out of custody.
Oh, okay, go ahead.
Upon arrival, Officer McCardle spoke with Jeremiah Julius Flowers. Jeremiah stated he got into an argument with his mother, Tracy Natasha Rose, over some hamburger meat. While they were arguing, suspect Antonio Sanchez Bailey stepped in between Jeremiah and his mother and was pushing Jeremiah against the arm of the chair. Jeremiah was antagonizing Antonio, telling him to hit him. Antonio then struck Jeremiah once in the left cheek and once in the left side of his head with a closed fist. Jeremiah said he went into the kitchen and Antonio thought he was going to grab a weapon. Jeremiah stated he knows better than to go back at Antonio, so he left the kitchen and went to his room to call 911. Officer McCardle took pictures of Jeremiah's right cheek and a cut on the inside of his lip. Officer McCardle had Jeremiah fill out a witness statement form. Officer McCardle provided Jeremiah a victim's rights form.
And I'm sorry,
Charges
the relationship
Sorry?
between Jeremiah and Antonio was what?
live-in,
I'm sorry?
a live-in. It was Tracy's boyfriend at the time.
All right,
The mother, Jeremiah's mother.
go ahead. Anything else?
Yeah, the charges were sent to City Prosecutor Cali for review and they were accepted.
All right, did you have that faxed over?
Yes.
What number was that faxed to, do you know?
Sent over the portal. So where?
1 second.
1 second. My sergeant's sending it over the portal right now.
All right. Amy, are you gonna dig that out for me? I can't really do anything until I get that signed. Where's John at?
We just got the approval. You just got the approval and it was sent.
Okay, can you tell me where you sent that?
He sent it via the portal, Your Honor. The
Okay.
33rd District portal.
Yeah, Amy, do you have that?
Yeah, something just came through. Yep, I got it.
All right,
I'll have somebody run it down.
thanks. All right, I'm gonna go ahead and sign that and date that and authorize the issuance of the complaint warrant, okay? So you're all set. Thanks.
Thank you, Your Honor. Have a good one.
But you signed it though, right?
Yes, Your Honor.
Okay, good enough. Thanks. Did you? I already handled it.
We did?
Yeah.
Okay.
Okay, she's got the complaint. Thank you. So I'm gonna take this thing. Thanks.
Yeah.
All right. People against William Estep. William Donovan Estep. He's the one.
It looks like he's still in the breakout room with host Mr. Fanego.
Okay, he sent in,
All right, I'll try to move him.
this is 20W82716 A and B. Mr. Estep, your name?
William Donovan Estep.
You met with the prosecutor. You're going to plead to retail fraud. He's going to dismiss the drug paraphernalia. True?
Yes, sir.
If you do that, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, sir.
If you plead guilty, you're waiving your right to a trial. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt.
Yes, sir.
The right to cross-examine their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. By pleading guilty, you're waiving all those rights, and we will not have a trial. Do you understand that?
Yes, sir.
Charge retail fraud. How do you still wish to waive your right to a lawyer?
Yes.
Charge retail fraud. How do you plead?
I plead guilty.
On November 20 of 20, were you at Walmart at 2380 Allen Road, Woodhaven at 5:42 p.m.?
Yes, sir.
Did you take property there that was offered for sale without paying for it?
Yes, sir.
Was that to the tune of about $160 worth of property?
Yes, sir.
Again, are you on probation or parole?
I'm on parole. I just did 4 years.
Were you on parole back in November of 20?
No, sir.
Anybody force you to plead guilty?
No, sir.
He's accepted to retail fraud. Drug paraphernalia is dismissed. How long you been in custody there?
I hear for a month.
Boy, you're not doing too good. You know that?
Yeah.
Anything you want to tell me?
Yeah. I just did 4 years in prison. After this, I'm case here.
100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 425 or 30 days. Credit 30. I'll give you credit for time served in the Wayne County Jail. Good luck. I hope you straighten out your life. I really do. Good luck.
Thank you.
People against Nicholas Edward Gilliland, 25U574138A and B.
Good morning, Judge Dion, with me on behalf of Mr. Gillis.
Mr. Gilliland, your name?
Good morning, Judge. Nicholas Gilliland.
He's going to plead to OWI 1. And, you know, they write these for OWI 2 when they can under local ordinance.
Right, that was the issue, so.
Did I bring that up before? I don't. Yeah, so he's going to plead to OWI. So essentially, he's pleading guilty as charged, and then they're going to dismiss the failure to display a valid license, right?
Yes, but I think it's the OWI first.
Yeah, but there is no OWI 2. They would have to charge under state law. Oh, wait a minute, this is under, but they didn't go and get a complaint and warrant. Wait a
They
second.
want to keep it open. That was the big deal from last time, just determining. Okay.
Wait a minute. What in the world is going on here? This is out of Brownstown. For Brownstown prosecutor, why is he saying that?
Well.
Come on in. Your name?
Caitlin Fuller, Carter, Brownstown Township, Your Honor.
Why was Mr. Fanego standing in for you?
I had to recuse myself, make Israel it.
Oh, okay. Okay, I get
So he
it.
did me a favor.
I see. Prosecutor Foley Carter recused. I'll make a note of that. I understand.
Thank you, Your Honor.
Okay, thanks. So
Verify the MES COD we did too.
the point is that they can't write these for OWI 2 under local ordinance.
Right, and I talked to the road patrol sergeant, and their intention was to keep it local. If they needed us to dismiss so they could reissue as OWI, that's fine. I didn't know if it would be okay, only because we're dismissing.
This is fine, but it's just kind of misleading to the defendant when they get an OWI 1 and they think they could have gotten an OWI 2. Do you understand they can't charge you with OWI 2 under local ordinance?
Yes.
That's a 1-year misdemeanor. Do you understand that? So what they're doing is they're writing this wrong. That didn't sound right. They're writing a wrong, so to speak, by pleading it OWI 1, but I want you to understand they can't have written you for OWI 2 to begin with. So really your pleading is charged on the OWI 1 and they're dismissing the no ops. Do you understand that?
Yes, sir.
You fully understand that?
Yes, sir.
And again, are you going to go into sobriety court?
Yes, sir.
It says this it's conditioned on your entry in the sobriety court. You're going to do that?
Yes, sir.
You're going to be stuck with me for 2 years, Mr. Gilliland.
Yeah, all right. I
I
was.
hope you're really ready.
For a long time.
If you plead guilty to this, again, I'm going to cover this. The possible penalties are up to 5 year all set. 500 fines, 93 days jail, 360 hours community service court costs are all. 6 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
And did you sign, read, and understand and advice of rights?
Yes, sir.
You plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right. To the charge, operating while intoxicated, first offense. How do you plead?
Guilty.
Were you operating a motor vehicle June 13 of 25 at 8:13 p.m. on Fort near Gibraltar in Brownstown?
Yes, sir.
Prior to that, did you drink alcohol? And if so, what did you drink and how much did you drink?
Yes, sir. I had, I think it was about 2 Jack and Cokes after I got off work.
What else?
I'm pretty sure 2 Jack and Cokes.
How
Unless
big-
I was messed up that.
Hang on a second. How big were the 2 Jack and Cokes?
They were big, like my own Jack and Cokes, man. Like at work, once I got off and then I left.
Okay, listen. How many shots did you have in each one of those drinks of Jack? Not Coke, Jack.
So I want to say like 4 or 5.
Okay, so probably about 8 to 10 drinks.
Yeah.
And was your ability to operate that motor vehicle significantly and materially affected due to the consumption of the alcohol?
Yes, sir.
Did you go get printed?
That's another issue, Your Honor.
Hang on, are you on probation or parole?
No, sir.
What was the breathalyzer or blood draw?
I'm not sure. I know it was over 22. 0.19.
Do you stipulate that that was an accurate reading for purposes of the plea of 0.19 or higher, sir?
Yes, sir.
Right now, you're not on probation.
No, sir.
Parole.
No, sir.
Please accept the OWI, and I'm going to dismiss the OWI 2 to the extent that it was valid, and it wasn't, and then I'm going to dismiss the no ops. What happened with the prints?
So he tried to get printed, he was told he couldn't. As of now, I believe he has to be printed by the Wayne County Sheriff. I'm not sure why he can't
Yeah,
be printed by.
I tried going to Trenton, Woodhaven, Brownstown. They all said they couldn't do it. So I called up here. I got asked for them to send another fingerprint order because I never received a physical one until about a week ago when I called and had to come in and get it again. But then she told me, when I called the first time, the clerk, I should have got her name, but she told me, since of everything that's going on, because I was worried about getting a warrant, since they wouldn't let me do it, I didn't know where to go. Everybody was just sending me in circle. I went up to Westland, because the woman at the, the clerk told me to go to Westland, so I went to Westland. They told me they couldn't do it. So they sent me to Wayne County off Russell.
Caitlin, can you come in here, please?
Did you go to Dickerson?
They told me, now they told me that since I didn't get live scan and fingerprint when I got booked.
I hate to get you in the middle, but you can help me with this. I know you can. Your name again? I know you're recusing. Can Brownstown print this, gentleman?
They can't, they can only because their live scan is in the booking room. I know Flat Rock, their room is outside of the booking room, so they might be able to. I know Amy and I were trying to figure out where they could go.
Would you talk to Amy? And I need him printed. You're going to go through your screening and assessment. We're going to give you a sentence date down the road, about 5 weeks. And I hope that you're going to take this serious and you're going to get into sobriety court. I think I offered this to you before, didn't I?
Yeah, I wasn't serious.
Well, okay, but you got to be now. Give me a date 5 weeks out. Tell them sobriety court. Go ahead. Amy, can you hear me?
Yes, sir. September 10th
Okay,
at 9 a.m., 8:30 a.m.
September 10th at 8:30 a.m. So maybe you can work on this, figure out, I need him printed for sure.
Wait, Judge, did he say that that Wayne County told him a place he can go? Can he go to Dickerson?
They told me to go to Dickerson because they have a live scanner and,
Well, did you go to Dickerson?
they just told me that today, but I had to go see the sergeant.
Okay.
At what, the Russell location.
All right, well, we're gonna give you your new date, and we're gonna give you the old order for prints, and you can go from there, okay?
Yes, sir.
You been going to AA?
Yeah, I have all my signatures.
He went yesterday.
I just got my.
Good. We'll see you here. Go over there. Tell them about sobriety court, John. Thank you. Good luck. Thanks. Tyler James Mexica, 23R 513-044, 25B 148704 AB.
Good morning, Judge. Deanna D on behalf of Mr. Mexica, state your name for the court.
Tyler James.
Let's handle the 513044 case out of Rockwood. Does he stay in mute, wait for formal reading?
Yes, Judge, I believe that Rockwood case is gonna be adjourned since.
Yeah, because I'm entering a not guilty plea. I'll somehow, some way figure out a way to give you a $500 personal bond. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. We'll give you the date. I'm just gonna send him down for you to give it to him, Amy. On this other charge, concealed weapon, he's going to have that case dismissed once he pleads to possession of a controlled substance. True?
Yes, Judge.
If you do-
7411.
Yes. If you do that and he stands mute and waives formal reading on both of those, true?
Yes, Judge.
All right. If you plead to possession of a controlled substance under 7411, I'll defer the proceeding. I'll place you on probation. I'll set terms and conditions. If you're compliant at the end of the specified period, the case will be dismissed. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you're giving up all those rights. You're subject to a 90-day jail term, fines 500, costs are all. Do you understand that?
I do.
And if you plead guilty, you're giving up all the rights on the advice of rights, and we won't have a trial. Do you understand that?
I do.
To the charge possession of a controlled substance, how do you plead?
Sure.
On July 11 of 25, were you on Telegraph near Joyce in Brownstown?
Yes,
Were
Your
you in
Honor.
possession of a controlled substance?
Yes, Your
You had
Honor.
multiple ones, right? Cocaine, Adderall, and Xanax?
Yes.
Anybody force you to plead guilty?
No, Your
Were
Honor.
they on your person?
Yes, Your Honor.
Going to accept your plea, find it to be an accurate plea, made voluntarily and understandingly. I'm going to give you a $1,000 personal bond. No alcohol, no marijuana, no illegal drugs. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. No contact with prosecution witnesses. No alcohol, no marijuana, no illegal drugs. Do you got that?
Yes.
AANA 3 times a week. AANA 3 times a week. I want you to go in person. We're going to give you a form. John, AA form, you need to start going immediately. We'll see you back here for sentencing. Again, that's on the marijuana charge, or the controlled substance charge rather, and the concealed weapon charge is dismissed. I'm going to give you a sentence date on that file. For the-
August, sorry.
Go ahead.
August 13th at 8:45.
August, I'm ordering a screening. August 13th at 8:45 will be your sentence date. You're going to go down the hall. You're going to get your notice on that case. They're also going to give you a notice on the Rockwood case. Don't confuse the two. Then you go down to probation. You're going to fill out a questionnaire and you'll be interviewed. They'll prepare a report and recommendation. You understand that?
Yes, Your Honor.
Any questions?
No, Your Honor.
Anything else?
Yeah, lastly, Judge, he's in NA right now through the guidance center
Through the guidance center?
in Southgate. Yes.
You're going to NA at the guidance center, or are you going to
Yeah.
treatment?
I do like the outpatient treatment
Yeah,
already, and I go to meetings.
How many meetings?
I do a bi-weekly one
Well, I'm gonna do this. I'm gonna make it. I'll make it a combination of AA, NA, combination of AA, NA, and or treatment. You have to go through 2-3 times a week. Do you understand that?
Yeah, sure.
Okay, so, yeah, he's going to treatment there, not AA. So I don't care if you're going to treatment once a week, you still need to go to AA then twice a week and vice versa. You understand that? So go down the hall, get your notices, go over to probation, fill out a questionnaire. Good luck.
Thank you, Your Honor.
Thank you, Judge.
Thanks. Barnier, Brianna, Ray, Barnier, 25B148694, A and B.
Dion Patillo on behalf of Ms., is it Barnier? Barnier, state your full name. Brianna Ray Barnier.
All right, so she's gonna stand mute, wait formal reading on both charges, right?
Yes, Judge, before we start this one, it appeared to be a conflict because I also represented the co-defendant that was just sentenced, Ms. Goff. So I did have that conversation with Ms. Barnier. She waived the conflict. I don't think that there's anything adverse since Ms. Goff has already been sentenced.
Okay, is that what you wanna do, Ms. Barnier?
Yes.
So you understand if the fraudulent scheme, that case will be dismissed if, in fact, you plead guilty to contributing to the delinquency of a minor. Do you understand that?
Yes, sir.
And that will be taken under the Homes Youthful Trainee Act. And if you're compliant with that, the case will be dismissed. Do you understand that?
Yes, sir.
And for purposes of arraignment on both, does she stand mute and waive formal reading?
Yes, Judge.
When you plead to contributing to the delinquency of a minor, I'll take it under HIDA. I'll set terms. And if you're compliant, again, at the end of the specified period, the case will be dismissed. This is punishable by up to 500 fines, 90 days jail, costs of all those. Do you understand that?
Yes, sir.
And did you sign, read, and understand an advice of rights form here today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that? To the charge contributing to the delinquency of a minor, how do you plead?
Guilty.
On May the 12th of 25, whoa, were you at 27232 Crawford Road in Brownstown?
Yeah.
What did you do to contribute to the delinquency of a minor?
I bought carts, leading to selling to a minor. Did you intend, when you purchased those carts, was it your intent to sell them to someone who was underage that could not have them? Yes.
And you did then in fact do that?
Yes.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it. $500 personal bond. I'll take it under HIDA. I'm going to dismiss the fraudulent scheme. Refer you for a pre-sentence report, okay? Pre-sentence report. We'll do a sentence date. That will be on August the 13th. Amy?
Yep, we could do that day.
At 8:45, okay?
Okay, thank you.
So that is dismissed. Good luck. Thank you.
Thank you, Judge.
Kayla Ann Felton. 25B82382383. Let's see, A, B, and C. And then let me see, 82383, A, B, and C. And then I also have 25B82688, A, B, and C.
Dion Patillo on behalf of Ms. Felton, state your full name for the board. Carolyn Felton.
Okay, so I'm gonna go ahead and, what are these? They're all being dismissed?
Yes, Your Honor.
Okay, so she voluntarily submitted the dog to be euthanized?
Yes, Your Honor.
All right, motion to the prosecutor, those 3 cases are dismissed. Am I supposed to take action on these other ones, or is she going to?
I believe the offer was for everything to be dismissed as long as she signed over the animal.
The dog's already been euthanized, right?
Yes. Because I believe 3 of them were before Judge Heston.
show the same case numbers on here. Caitlin, can you come out here, please? Can you just clarify this for me, please? The case is in front of Judge Hess, and it looks like you're dismissing as well, right? So, but you got the same case numbers, it looks like, on all of these. So it's 25, can you hand her that? 25B 826, 25B 826, A, B, and C. And ma'am, those cases are dismissed as well then, okay? You're all set. I wish you well. Thank you.
Thank you, Judge.
Thank you, Judge.
Thank you. Who's Jay Nolan? Oh, I see. This is Jay Nolan.
He's in county, I think, Judge. They didn't bring him. I just.
Hi, Jake Quayle, Orion Nolan, 25B 148261. Yeah, we'll have to reset case. Defendant not put in front of camera. How you doing, Mr. Gay?
Good, how are you, Judge?
Good. Are we done?
Ms. Patillo has one more, and we got a couple no shows.
Ms. Patillo, you ready
Yeah,
for
I got
the other
one
one?
more.
Are you done?
It just, well, after I talked to him.
Okay,
And
good,
then that's it.
perfect.
That's it, just one more.
No show, Judge.
Thank you.
People against Bailey, Leanne Dow, 25B 148814A and B. On the A file, we're gonna go ahead and issue a show cause. That's the first miss. And on the B file, default judgment will enter. People against Raymonte Ronald Young, 25B 148921A and B. On the A file, we're gonna go ahead and issue a show cause. On the B file, I'm entering a judgment. Default. Okay.
We just have one more, Your Honor. I got a call from John. You got a call from what? I got a call from you. Oh, I was trying to close. Oh.
I think we're just waiting on the one then, right? Okay. Everything good?
Everything good, Judge. Yeah, I just walked out of a arraignment with Elias. He's in custody. On the same charge, we got dismissed here last week.
Oh, the trespass?
Uh-huh. She got this new one. Yeah. Oh, he fired me.
I hear your excitement.
Yeah, I know, I'm trying to hold it back.
Thought I'd just throw that out there. I'm just observing. Well, I didn't expect Simon, Karen. Court does call the case of the people, we call the case of the people versus Burns.
Good afternoon, Graciela, the prosecuting attorney about people.
And good afternoon, Your Honor. Assistant Public Defender Shanazi Kyriakin-Riley, on behalf of Mr. Jerome Burns. Mr. Burns, would you state your name for the record?
Jerome Burns.
All right, very good.
Your Honor, thank you for the court's patience and allowing us to talk through a few things. As I indicated to Your Honor and Defense Counsel, I've looked through a great deal of evidence. I was handed a essentially summarized report by the detective who did the extraction from the phone. I shared that for today's purposes with Defense Counsel. We both kind of skimmed through it. With what was in that report, I felt comfortable proceeding today with the responding officer, with the social worker witness, and starting with Sergeant Matthews. I was not necessarily comfortable proceeding with the testimony from the victim until I've looked at everything more at length. So I guess we wouldn't have a request to adjourn. However, we also understand defense counsel's side of things and want to be understanding of the concerns that she has at the time that she may need to look through everything. So we also wouldn't object to an adjournment at this stage.
And Your Honor, I think that she did state the fact that there was a new summary that was provided to us today by the officer who was able to do the extraction from the phone. I did have an opportunity just to glance at that summary. I spoke with my client. Previously, the court is always obviously aware that his position was for us to continue on with the exam today. In light of the new information, by way of summary that was submitted to us today, I need time to go over it with my client and see if there's any insight or context that he would be able to add to it for me. Most of this is communications with the complaining witness specifically. So there's just a lot of information that we have still yet to go over. So I guess that although my client, for the record, is not asking for the adjournment, we're just letting the court know what position we're in right now with the information that's been presented to us.
All right. Understood. And so from the court's perspective, and I'm going to adjourn the matter, finding good cause to do so. Counsel's been very good at explaining to me exactly where the parties are. I think it would certainly behoove the defendant to be able to have his attorney go through that information and then go through that with him in fairness. As I also expressed to counsel while we were in chambers, I strive to make sure that the decisions that I render in these cases, in every case, is the correct decision. And it would worry the court a bit that if there's information out there that is not being provided to the court that may give either some context or understanding as to the testimony that I'm hearing. So for those reasons, the court will adjourn the matter. I will be adjourning it, also part of the discussion in back, realizing the defendant is in custody, has been in custody, and that there are, without going into the details of it, vacations that are scheduled and other things, plans that people have made, and so that we can have consistency. We picked August 13th as a date to continue. Court's going to do, and that we'll do that August 13th at 9 a.m. The court, for its part, is flipping its docket to handle what would be in the morning, in the afternoon, to try to accommodate this and to make sure that we get this done in at least a reasonable period in time. Counsel has also let me know they think that will be enough time for them to be able to get through everything. So that there's a full understanding, and from the defense side, being able to also discuss that with the defendant. Right, so August 13th, 2025, 9 a.m. for me for the continuation.
And Judge, if I may address first? Your Honor, with obviously the court is very aware of the continuances that we've had in this matter. Mr. Burns has been in custody for 81 days to date from the date of the original arrest. I know that there is a current issue, or at least a bond violation that he has already entered a plea to, that the court has yet to sentence him for. I do not know what the court is going to do. I'm not sure if the court has been able to make a decision, especially based on the status of the case as is. I received information from my client's mother on yesterday that his father is currently in the hospital. He suffered a stroke on Friday, and he has been hospitalized since then. because my client does not have telephone access or anything of that nature, he had been completely unaware of that until I had spoken with his mother. And then I was able to relate that information to him. She has been finding it very difficult to handle her husband's affairs and to assist with his medical upkeep, especially when he is going to be released by God's grace. He will be able to be released sometime soon, and he'll have a significant treatment regimen that he will have to undergo. I know the court is aware that my client lives with his parents and had been living with his parents prior to this situation. They're not considered as elderly, but they are older. And his mother will need some assistance. I know that the court has heard some testimony in this matter. We'd like to ask that the court consider giving him a bond that he would be able to post, ideally, preferably a personal recognizance bond. I know that there are things that the court can put in place to protect or address any concerns that they may have for the complaining witness. He is not a flight risk. The court knows that his parents have been at every one of his court hearings from the beginning. So we know that he himself will be at every one of the court hearings based on what he has assured us. The way that this case has gone in so many different directions, Mr. Burns 1000% understands that he is fully in control of what happens next. If the court is willing to give him a personal recognizance bond, I dare to say that he understands that any actions on his behalf would negatively impact his case, because they have. Everything that has happened thus far that has brought us to the number of continuances that we've had. I've spoken with them. Most of them, if not all of them, have to deal with some type of action that was taken by him. If that has not taught him that his actions directly impact the outcome of the case, or at least the ability for us to try this case in a fair manner, I don't know what else would help him do that. I believe that he is understanding the importance of maintaining his bond. I believe he understands the importance of no contact with the complaining witness in any shape or fashion, with the issues with his father, the assistance that's needed by his parents. We're asking that the court make a consideration of giving him a bond, and if in the alternative, judge, at least allowing him to be able to communicate with his parents so that he'd be able to keep up with what is happening with his dad. We prefer that he be given a PR bond. I mean, he has been trying his absolute best to aid in his defense from the jail. It has been quite difficult because he only has his parents to rely on to relay and give us whatever information they may have. So that is our request today. Primarily based on the number of continuances that we've had. I know we've talked about it on the record, and not that anyone is at fault for that, but he's been in jail for 81 days on this case, Judge. So we're asking for a personal recognizance bond.
Your Honor, we have a great deal of concern in this case. We had a concern initially when this case was charged. That concern has done nothing but grow as this case has progressed. We heard testimony from the victim, quite extensive testimony about the level of coercive control that this defendant had on her. That gives us no hope that that has changed. Part of the reason that we don't have that hope and don't believe that anything's changed in his mind for the better, at least if anything has changed for the worse, the actions he took while he was incarcerated after being given very specific conditions of bond. At that point, it should have been clear to him, if it weren't previously, that engaging in behavior that makes things more difficult for the victim, who is the mother of his child, is not going to be beneficial to him. What he then decided to do is make several calls, ensuring, first of all, he fought her having access to a vehicle to transport their sick child while we were in court. Even to the point where his father was willing to hand over keys, and we thought we had it resolved, and he refused. Then when the court ordered, keys need to be turned over to the victim, she needs to have transportation. The court had a long conversation with him about the situation and what would be appropriate, what he needed to do. He then decided it'd be a good idea to have people, third parties, contact the bank, trying to get this car repossessed, going so far as to say the victim who was staying at the domestic violence shelter at the time make sure that they come and repossess the vehicle as she's trying to unload her things. I mean, this is a woman who has had everything taken from her. She has no place to live. She had no transportation, and she's caring for a sick child, defendant's sick child. He also, during those calls, made statements about how he would have assaulted Your Honor if he wasn't handcuffed. All of that is plenty concerning. And in addition to that, he made statements on the jail calls, and we heard through the victim's testimony that he has made statements, and I believe the evidence we now have is going to corroborate that, of taking their son away, and that the victim would never see their son again. She also testified, of course, that that was part of the reason that she gave in this case to the sexual assault, and it was a big part of her concern in this case. So when we're talking about victim safety, we have concerns because of that coercive control, because of the hourly check-ins he required from the victim, knowing exactly where she is, who she's with, and so on. That doesn't just go away. We also do have concerns that he would take their son and disappear. So both for flight risk and for victim safety, we have a lot of concerns. We'd ask the court to deny the motion.
Yes, Your Honor, I just wanted to address a couple of the issues that were raised by the people. At this point, my client does not have a vehicle. The vehicle was turned over to the complaining witness, and obviously the court is aware that the vehicle is either not working or something to that effect, because the complaining witness has needed assistance from the people to get to court on each of these hearings. So he is going to completely have to start all over. We've already pled to the bond violation. I think that it should be noted that no contact with the complaining witness was actually made. There were attempts from my client. We do not deny that, Your Honor. Most of that was due to frustration and what he was dealing with at the time, and just trying to understand how he found himself in this situation. He has taken responsibility for that. And I think that that should give him some type of a benefit of the doubt, Your Honor, because he has been able to take accountability and responsibility for the actions that he did commit. However, the complaining witness left the home that was shared by all of these parties well before this incident happened. He does not have any control over her. If he did, she would have still been in the house. The only reason that we're here right now is because their son was in the hospital, and they were at the hospital together. Whatever control or coercion or dominance the people believe that he has over the complaining witness, there has been no showing that that is the case ever since she left the home. So I don't think that that is a concern that the court should have. My client has much more important things that he needs to worry about right now, rather than whatever it is that's going on with his relationship. He has not tried to contact her directly while he was here. The only contact that was alleged was the fact that he asked someone to go and have the car repossessed because it's up for repossession. And I mean, quite frankly, Your Honor, he is still financially responsible for a vehicle that he no longer had control over. And his position was, if I don't have control over the vehicle, then let the bank take the vehicle back, and everybody will just deal with things the way that they were dealing with it prior to that. I do not think that the court should or would have any concerns with my client contacting her, having any issues. He wants to focus on his family, his father, and his mother. He has work that he needs to do, Your Honor. He needs to be able to help his parents financially. That is the position that we're in right now. He has to start all over. He has no leg to stand on right now other than a place to live, which would be at his parents' home. I think that a hot zone tether, a tether of some sort, would be able to protect him. He doesn't even have a phone, Judge. The phone that he did have is in the possession of the police department. He would be using his parents' phones, if anything. So he doesn't even have much to work with. So I don't think that the concerns that the people have for the victim's safety or the complaining witness's safety in this matter are valid, because my client can barely take care of himself at this point.
The court, having looked at it and also having been familiar with the bond violation that I've yet to sentence the defendant on, certainly given, and again, it's not anyone's fault necessarily, the continue time to make sure that all of the evidence is properly analyzed by each side, the court, in any sentence that it does impose, and I did represent this to counsel, will take into account the time that the defendant, I'm not making any guarantee as to what extent, but we'll take that into account in terms of any sentence that it would impose. I still do consider the defendant to be a risk to public safety and to the victim in particular in this case, and would deny the defendant's request for a bond reduction at this time. I will, however, given light of given notice of the circumstances involving his father. His father, I know, had been in these proceedings in the previous times, that I would permit, although I have revoked his phone privileges, to the extent it can be arranged with the Washington County Sheriff's Office and jail, I would permit the defendant to call his father while he is at the hospital one time per week, so that at least he can have communication with his dad. All right. And maybe then facilitate some of the issues that his mother might be running into in terms of the caring of the house. So counsel, if you prepare an order to that effect. But once, so that I'm clear, once his dad leaves the hospital, his phone privileges will go back to the status of being absolutely revoked. All right.
May I just add one thing? I'd asked the court because part of, and I was going to respond to counsel, but I felt that unnecessary at the time. Part of the jail calls indicated that he was asking his parents to contact the victim to have her essentially get rid of this case. So maybe a warning that, so he's very clear that these conversations, once a week, cannot be about the case, about the victim or anything like that. Thank you.
Yes, and I think that ought to be clear, and you understand that, Mr. Burns. Yes. All right. So the case should not be discussed, certainly no directive should be given to your dad in terms of what to do or anything else along those lines. If I find that to be the case, that's just going to be another violation of my order, and I don't think we want to end up in that situation. All right. I'm doing it solely because having found out this information, your dad's in the hospital. I think that as an act of grace, the court is going to give you the opportunity to at least speak with your dad. All right. Okay. Thank you.
Thank you.
All right. Folks, I realize we're running a bit behind. You can see that I've been dealing with that. You're gonna have to give me 5. I'm gonna take a brief recess. I'll come back and then we'll start calling cases. Court's in recess.
All right.
Yeah.
Okay.
And license and registration. No clue, but I have plenty of cases to object. I'm grateful for any help. Let's see.
I would like to note on the record that it is my preference to keep these separate. Just wanted to make that heard.
That will be noted. Please note that on the record. An unclassified, 2 unclassified, you don't have to make bond in that case. So I'm going to order that you reappear at the date and time given before Judge Ricky. Did he say whether he wanted that by Zoom or in person? Counsel,
My request would be to be in person. And also I did want to state one more further thing for the record that the judge had during, like I had mentioned earlier, but wanted to make sure the record reflected that he was not planning to put them together. So just making that available. Thank you.
Thank you. All right, well, you may go, sir. Choose from these proceedings. Just make sure you reappear at the date and time given.
Okay, and one more time for me, please. The date.
August 25th at 2:30, didn't you say, Destiny?
I show at 3 p.m., Your Honor, but
Okay.
August 25th nonetheless.
August 25th, 3 p.m. And did he say again, in person, or did he specify Zoom or in person?
I show that the other case is set by Zoom, so I would presume that both will be set by Zoom, Your Honor.
Okay, you might call back close to the date and confirm that that's right, sir.
Okay.
If you want a court-appointed attorney, you need to turn in an application for one. Do you want an attorney?
I do not.
Okay. All right. You may go, sir.
Thank you for your time.
Thank you for yours. Okay, can we block his if he's through, Missy, can you block him, take him away, close him? Fitzpatrick, we're on the record in 2025, TR 256, State of Kansas versus Nakia K. Fitzpatrick.
I'm here, Judge. Good morning.
Good morning, thank you. Brett Sweeney for the state, the defendant Fitzpatrick in person. Ms. Fitzpatrick, this seems to be a review. You said on May 7th, 25, you're going to apply for diversion. Did you do that?
I actually got off the phone with you and got on there, and I was not aware that it was a $50 fine, $50 to get it started. I was not working. I just moved to Wichita. I had got hired onto a job, Eckerd Connect, but it took me 2 months to get in here. So I'm finally working, and I just wanted to see if I can get a continuous to go through the diversion now.
Mr. Regier, any objection to continuing this?
No objection, Your Honor.
All right, I will continue this at the defendant's request to Wednesday, October 29. Either be diverted or be back here October 29 at 9
Thank you,
a.m.
ma'am.
Welcome.
At 9 a.m.?
Yes, yes.
Okay. Thank you. I
Yeah.
will look into that. I should get paid at the beginning of the month.
That's good, thank you. You may go.
Thank you.
Welcome. We're now on the record in 25 TR 1057, State of Kansas versus Vashwanda Renee Hill. Brett Sweeney for the state. Is Miss Hill here?
I'm here.
The defendant, Miss Hill, appears in person and pro se. In count one, your charge was speeding 90 and a 75. On count two, driving while suspended. How do you want to proceed, Miss Hill? Do you want to have an attorney?
No.
You want to look into diversion?
I don't know if I should just plead no contest or apply for diversion. I don't know which one would be the best option.
Well, you have to qualify for diversion.
I have no other prior offenses.
All right, I will enter a not guilty plea and continue this. Can you get on that website and start that today?
Okay, I've already started it. I have a question about the website. I have filled out everything. It wanted me to upload my ticket, and I don't even know where it's at.
Well, call the county attorney and ask for the diversion coordinator. The number is
Okay.
316-321-0000. 6999. I'm setting your case for Wednesday, October 29th at 9 a.m. Either be diverted or be back here at that time. And you need to talk to the officer in the court security breakout room with the blue uniform. And your bond is going to be set at 1,000 OR. You won't have to put that money up unless you fail to come to court. And of course, you don't have to come if you
Okay.
get diverted, but you do have to get your picture and prints taken. Missy, can you put them in a breakout room? Vashonda Hill, and
Your Honor, what was that date again?
it is October 2nd or 29th. Let's see, October 29th at 9 a.m.
Thank you, Your Honor.
Thank you. So if you please put Miss Hill and court security in a breakout room.
And Your Honor, if I may be excused, my colleague, Mr. Regier, is here, so I appreciate you making allowances for me to appear and sub in today.
No problem. Good to see you again. Thank you, sir.
Likewise. Thanks, Judge.
Bye-bye. Will now be on the record in 2025 TR 132, State of Kansas versus Nathaniel Lee Klein, Jared Regier for the state, and Mr. Klein in person and pro se. Mr. Klein's here on one count of a registration violation. How do you want to proceed on that, Mr. Klein?
Your Honor, I want to do diversion. I want to apply for it.
All right. I'll continue this if there's no objection at the defendant's request to Wednesday.
In your honor,
Yes.
we're full on October 29th now. So the next date we have available is September 5th.
Well, I see something about October 27th. Oh, I see. I was looking at the wrong one again. September 5th. September 5th at 9 a.m. You must be diverted or be back here, Mr. Klein, ready to go.
Okay.
If you decide you don't get diversion, you want a court-appointed attorney, you need to come get your application. Don't wait on anything until the last week or two before.
Okay.
Get it done as soon as possible. Okay, continue at your request, bond to continue with that added condition, Mr. Regier, anything further?
Nothing to say, Your Honor.
Okay, Miss Deputy, I show he did post a bond of $500. Yes, sir.
Yeah, there should be a bond on there.
I don't see these processed.
Miss Hill, are you not able to go into the breakout room?
No.
I've sent you two different invites.
And it's up there in the corner, says join the breakout room, and a person joined and it won't go to it. How do
I don't know. I wonder if your service is not good enough because you're breaking up. I'll try it again. But yes, as soon as it comes on there, click on it.
On the record in 2025 TR 1029, State of Kansas versus Tracy Rainick Lundberg. Jared Regier for the state, Tracy Lundberg. is here in
Yes, Your
person
Honor.
on Wednesday. Ms. Lundberg, in count one, you're charged with driving without registration and unclassified misdemeanor. Penalties include up to 2,500 in fines and 30 days to 6 months in jail. Count two, driving without proof of insurance is a B misdemeanor. It has penalties of 300 to 1,000 in fines and up to 6 months in jail. Driving while suspended has a minimum fine of 100 up to 1,000 and up to 6 months in jail. Do you intend to hire an attorney, apply for court appointed, or waive attorney and represent yourself?
I'm not sure. I have fixed the expired tag and the insurance. already, and that tag is now valid. They just needed an SR2 form from my insurance, and that's why it was expired. So my insurance.
Are you wanting to apply for diversion then?
Yeah, because I'm just very confused because I have a valid license in Arizona, and I was given a license there in 2017, and in 2022 Michigan suspended my license. So I'm unsure how that happened, but I contacted them and I have 2 fees to pay and then they'll reinstate.
Well,
So I'm not really
you
sure.
want to go for an attorney or not? You don't want an attorney or you do?
Yeah, I'll do an attorney and have them help me take care of the legwork
Are you
on
able
the
to hire an
suspension.
attorney or do you need to apply for court appointed?
Court appointed.
Are you employed?
No, not currently.
How long have you been unemployed?
For the last 7 months.
What kind of work do you do when you are employed?
Admin, medical administration.
Okay, well, are you married or single?
Single?
Do you have any minor children that you help support?
No.
You pay all your own bills or do you have some help?
Help from my mom.
I'll appoint attorney Darren Patterson.
Okay.
After court, call him at 316-322-7700. And you'll need to reappear September 5th at 9 a.m. unless you're diverted.
And Your Honor.
Okay.
Oh, is this, yes.
It's October 20th for Mr. Patterson, but that is the last one available on that date.
All right, October 20th at 8 a.m. Claims Act, October 20th at 8 a.m., Ms. Linder.
Okay, October 20th, 8 a.m.
Yes,
Okay.
and we'll need to go in a breakout room with the officer, court security 2, and I'm gonna set your bond at 3,000 cash or professional surety, no, cash.
Okay.
Strike that, any OR. 3,000 OR. You won't have to put the money up unless you fail to come to court. And one of the conditions in your bond is that you call Mr. Patterson today. The staff may all be at lunch, so keep calling until you get to.
Okay, you said after 1:30, correct?
I'd try now, and if they don't answer now, then I'd try probably after 1:30.
Okay.
Deputy Throckmorton, did you have something?
I just did not catch the next court date on the previous last decline.
The last decline, Clark, what did we put on decline? Yeah, this,
Your Honor, I have September 5th at 9 a.m.
yes, September 5th, 9 a.m. Thank you.
Your Honor.
Thank you so much.
Mr. Regier?
Your Honor, the state understands that September 5th is a Friday. I'm not sure if the court is scheduling a special setting docket on that day.
Let me check again just to make sure.
We may have to, because we've been putting quite a few people there, I think.
And Mr. Aguirre is correct. It should be, let's see here.
Well, we've got quite a few people there. We may just have to see if we can have a court date there, Destiny.
I think only the one. I think we've only put Mr. Klein on there. Goodness gracious.
Lundberg?
Yes.
I apologize. It should be November 5th is the date.
All right, you have to be back here at that time, Mr. Lundberg.
November, or was it October? I'm sorry, I got confused.
Mr. Klein should be November 5th, but I believe that Ms. Lundberg should still be on October 20th as she has Mr. Patterson as an attorney now, correct?
Can I have can I have his phone number one more time?
I'm sorry, there's a lot of other noise going around and I couldn't hear you very well, Your Honor.
All right, so when's our next court date?
For Ms. Lundberg, I have October 20th at 8 a.m. with Mr. Patterson appointed to her case.
October 20th. All right, anything further from either party?
Can I just, I'm sorry, Your Honor, can I have the, his number one more time?
316-322-7700.
Thank you.
And Your Honor,
Mr. Regier?
is the court also ordering that the defense submit herself for booking besides the $3,000 OR bond in this case?
One more time, what was that question?
Your Honor, is the court also ordering booking in addition to the appearance bond ordered by the
Yes,
court in this
yes.
matter?
Yes,
Thank you, Your Honor.
all right. There's nothing further. We'll be in recess on Lundberg. We'll now be on the record in Neil. Thank you. You may go, Ms. Lundberg. 2025, well, wait. You need to go into the breakout room, accept the breakout room invitation. Hope she did. On the record in 2025 TR 1020, State of Kansas versus Archie James Neal. Jared Regier for the state. Archie James Neal.
I'm here.
Person and per se. Mr. Neal, in count one, you are charged with speeding 75 and a 65, an infraction that carries a $45 fine. Count two, driving without proof of insurance, a B misdemeanor, carries a fine anywhere from $300 up to $1,000, and a possible jail sentence up to 6 months. Probation is an option. Mr. Neal, do you want an attorney or do you want to represent yourself?
I can represent myself, ma'am.
Or do you want to look into the diversion program?
I would think diversion is the way to go for me.
All right, I'm going to enter a not guilty plea. So you can look into diversion, and if you don't get it, come back here.
November 5th. I apologize, Your Honor.
November 5th at 9 a.m.
Yes, ma'am.
All right, anything further from anyone?
Your Honor, this is the defendant who, based off the state's records, appears pursuant to a notice of appear date on the ticket, and count two does appear to be charged as a Class B misdemeanor based on the ticket.
You'll need to go into a breakout room with court security 2. I'll set the bond at 1,000 OR. Do you need to arrange to get those picture prints taken for Kansas law? So look for that invitation to the breakout room. We'll now be on the record in 24 TR 2997, State of Kansas versus Mackenzie Riley Newsom. Jared Regier for the state, Mackenzie Newsom. Mackenzie Newsom fails to appear. She's one count of liability insurance. You haven't dismissed that, have you, Mr. Regier? Let's see that. Ms. Newsom did post a bond that was filed April 10th of 2025.
And Your Honor, in response to the court's previous inquiry, the state is not aware of any amended information filed with the court in this matter.
All right. Going to issue a bond forfeiture bench warrant, $2,000 cash assured bond.
And Your Honor,
Yes.
it would, just for the record, it would appear that, based off my notes, that at the last sitting, May 7th, at which time the defendant appeared, representing herself, the matter was continued for purposes of finalizing diversion. I am showing that a diversion agreement was circulated by my office in the interim, but at this juncture, I am not showing any diversion agreements having actually been filed with the court.
Same here, so those orders stand. On the record in 2024 TR 3006, State of Kansas versus Elisa Raquel Ordonez. Is Jared McGee for the state? Is Ms. Ordonez here? Yes, she's here in person.
Yes, Your Honor.
Ms. Ordonez, you told me in January you're going to apply for diversion, did you?
Yes, Your Honor, I did.
Were you accepted?
I had called the court in February and they had told me that my diversion was accepted and that I should be receiving next steps in the mail, and I never received any. And then a warrant was put out for my arrest because I failed to appear for a court date on May 7th. But once again, I take full responsibility for that. I did not know that I was supposed to appear in court on May 7th.
Well, I will continue this to see if you can pursue that any further or not. Continue it to, what's my next traffic docket, November 20th?
November 5th, Your Honor.
Continued at defendant's request to November 5th at 9 a.m. Get the diversion or be here, and we need to resolve this at that time.
And Your Honor,
Yes?
for purposes of the record, the state will be objecting to any additional continuances at the next setting. If it comes to that, based off my notes, it does appear that a diversion agreement was circulated by my office approximately 6 months ago in the latter part of January, but I'm not showing that a diversion agreement is on file with the court at this time.
All right, that is noted. Please make sure you know that, Ms. Ordonez. You're excused
Yes.
at this time.
Your Honor, I have a question. What am I supposed to be doing in that time while I'm in order to get this resolved in between now and November 5th?
Call the county attorney's office and ask them because it is their program.
Okay, and what's the phone number for them?
316-321-6999.
Thank you, Your Honor.
You're welcome. All right, we'll be in recess on Ordonez. We'll now be on the record in Pendergraph 2025 TR 181, State of Kansas versus John Dale Pendergraph Jr. Jared McGee for the state is the defendant here. Defendant fails to appear. Recommendations, counsel.
One moment, Your Honor. Your Honor, the state does acknowledge that pursuant to the information in this case, this is a case that appears to involve 2 alleged counts, an infraction and an unclassified misdemeanor. However, it is the state's understanding that this matter initially came before the court back in April, at which time the defendant failed to appear. This would appear to be the second consecutive failure to appear. I'm not showing a successful first appearance in this case. Additionally, I am showing an appearance bond in the amount of $1,000 professional surety. It appears to refer to today's date and time, specifically July 30th, 2025 at 9 a.m. With all that being said, the state is seeking a bench warrant bond forfeiture, no bond hold in light of the second consecutive failure to appear based off of the state's records.
That is the recommendation, bond forfeiture, bench warrant, no bond hold.
Thank you, Your Honor.
You're welcome. We'll now be on the record in case number 2025 TR 270, State of Kansas versus Monho Kumar Richavondran. For the state, the defendant here in person and first say.
Hi, everyone. Good morning.
Good afternoon.
Yeah, good afternoon, ma'am.
So you are charged with operating without a registration or expired tag in count 1 and no insurance in count 2. Do you intend to have an attorney represent you, sir?
No, ma'am, like, I had a hearing before and it was discussed that I will be, getting into a diversion program. And also like, I went to the Butler County, county jail and, I also gave the photographs and the bond signed.
All right, you did tell me on May 7th you're going to go through booking and processing for the $1,000 OR. Did you do that?
Yes, ma'am, I did that.
All right, you did that. And then you told me you were going to look into diversion. Did you do that?
Yes, ma'am, I did apply for the diversion.
Did they grant it or deny it?
I didn't get the report yet, ma'am, or like, it's been like, 4 weeks since I applied. Uh, I'm not sure, like, I didn't get any, update yet. Maybe I should be calling the court and, checking on the diversion officer and checking on like, what would be the case.
So you did apply. You turned in your application.
Yes, I did apply for my application.
And did they send you a contract or tell you that you were denied?
I didn't get the response yet on that.
Your Honor, if I
I'm
may.
Still waiting on it.
Go ahead, Mr. Okay, let's see what Mr. Overgear has.
Your Honor, it would appear that between today's hearing and the previous hearing, a diversion application was received and approved by my office. I am showing that a diversion agreement was circulated by my office approximately 3 weeks prior. However, it does not appear a diversion agreement is on file with the court at this time.
All right, Mr. Shabandran, what you need to do is call the county attorney's office and see where that application is, or that contract is. Their number, are you ready for it? You have their number?
Yes. I'm sorry?
You have the county attorney's number, or would you like me to give it to you?
Can you please call it out?
I'm sorry, I didn't understand what you said.
Ma'am, can you please call out the number? I don't have it. Can you please call out the
All
number?
right, it's 316
Uh-huh.
321
Mm-hmm.
6999.
Yes, ma'am. Thank you.
You're welcome, and we'll continue this at your request to, let's see. What date are we going to? November?
November 5th, Your Honor, yes.
November 5?
Yes,
5,
ma'am.
yes.
November 5th at 9, but if you're diverted, you won't have to be here.
I have to be there, you're saying?
If you're diverted, if you've signed your contract and sent it back in, you will not need to be here.
All right, ma'am. And ma'am, I also have something additional to share with the court. Can you go
Okay.
ahead?
Go ahead.
The last discussion when we had, like on the last court hearing, I was informing you, I was informing the court like I would be doing an international travel, and since my parents are not good, I have to be there back in India, and I'm an immigration student. So I came back to India right after signing my over. Then like I had the case what I had was like no insurance coverage and no registration tag on my car. Later, like I was able to get back onto my insurance, but my car was there back in US and it was in San Antonio. My friend was driving and he met with an accident and the car is total right now. So I don't know like whether I could be discussing the scenario with the diversion officer and asking what could be done, or like would this be the best place to discuss on that?
Go to the diversion, if you would, that, because I don't have any say on what to do about it, other than to take it off the docket if you're granted. So call the county attorney's diversion officer about that.
I will just, it does acknowledge the service that you give to the people here. This court does acknowledge that this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of IOP treatment, attendance at weekly AA meetings, and abstinence from all intoxicants. Therefore, the court and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. This is therefore the sentence of the court that I will place you on 18 months probation. I will order $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $540 probation oversight fees. When can that be paid?
I can pay it today.
Thank you. It will be paid today. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an intensive outpatient substance treatment, including all outpatient substance treatment, including all recommended aftercare with status reports to probation. I will just note in that regard that much like with any defendant, that where an accommodation is required, we will provide that accommodation for the defendant.
Thank you.
You are to attend 2 AA meetings per week with monthly verification to probation. You provide proof of victims impact panel attendance to probation. I will continue to scram tether for an additional 30 days in lieu of 4 days in jail. However, 93 days in jail, credit 1, the balance is suspended. Thank you. Up to you, Ms. Katie.
Thank you.
Thank you, Judge.
Thank you. Court does call the case, People versus Edward Harris. Okay, can you hear me, Mr. Harris? Can you hear me?
Yeah.
Okay, good enough.
How you doing, Your Honor?
I'm doing well.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Harris. Mr. Harris, can you state your name for the record, please?
Edward Harris.
Just to clear on behalf of probation, Your Honor, Mr. Harris is before the court for violation of probation hearing. Mr. Harris is in violation of the terms ordered by this court in that he owes a balance of $1,095, having made no payment. He failed to report to probation as directed, failed to provide proof of substance abuse treatment, and failed to complete or provide proof of a mental health assessment. Mr. Harris additionally has had new police contact with a new case being filed or submitted to the prosecutor's office. Your Honor, that alleged date of offense was May 3rd, 2025, with the requested charges of larceny in a building. Probation is also aware that Mr. Harris has in violation of probation hearings out of circuit court. That's going to be addressed there. It's my understanding from the felony probation office that he's likely to serve jail time in those matters. Given all of the circumstances, probation is recommending that Mr. Harris serve 365 days in jail with credit for 88 days that he served the balance. He completed the in-jail NRT program for the court to consider early release upon completion of that, waiving all other terms except his financial obligations and discharging him from probation.
You know, I did have a chance to speak with Mr. Harrison, Ms. Pilara about this. I'm going to ask for an adjournment of this hearing, actually, to see what happens both on the felony case, as well as I would like to get some documentation from Mr. Harris's caretaker, his sister. He's been having pretty significant memory issues.
he had an aneurysm earlier this year. And I want to make sure that if that could have an impact on the sentence, the court and probation has that information. And to see if felony probation has that information as well. I mean, frankly, Your Honor, if I ask Mr. Harris if he's been diagnosed with dementia or Alzheimer's, he doesn't remember. So he's been having some memory issues, and like I said, his sister is his full-time caretaker. So I just would like a chance to speak with her more, to know more about what's going on with him.
Well, it would seem to me that both could happen. I mean, the significant penalty in this case is the jail time that I would be imposing. I am certainly, if information is provided after you speak with this, is to probation and into the court to reconsider the amount of time, if any, that the defendant would serve. So I'm going to decline the adjournment. I think I'm going to go ahead with the sentencing with that caveat that if you provide that information, I'll take a okay.
Sure. If anything comes to light, I'll get it to the court.
All right. Okay. Sir, anything you want to tell me before I impose sentence?
No.
All right. Given all of that, I'm going to order 365 days in jail, credit 88 days that he served defendant, and I'll order the defendant to serve the balance. I will indicate also that the defendant is to complete the in-jail MRT program. I will consider an early release upon completion of that program, as well as if other factors are submitted to the court that would dictate an early release. I will waive all other further terms except his financial obligations, discharge him from probation without improvement.
Your Honor, if I may ask one question.
Yeah.
I don't know if when Mr. Harris walks out of this room, he's going to remember to enroll in the MRT. Will the jail, since it's court ordered, will the jail automatically enroll him? Do you know? Or any
I don't
of our
think it's automatic,
officers?
but
I can get in touch with the jail and see if
why don't we?
they can help me
So
facilitate that.
Okay.
Okay.
We'll do it that way.
Okay. Thank
All
you.
right.
Thank you.
Thank you. You take care of yourself, sir.
Okay.
Let's call the case of the people versus Daniel Noble.
Good afternoon, Your Honor. Brendan Paulson, appearing on behalf of Daniel Nagel.
I'm here as well, sir.
State your name for the record, sir.
Daniel Allen Nagel.
You have it. That's all one.
Hello?
All right. Yes. Go
Oh,
ahead.
okay.
Your Honor,
Making-
go ahead. I'm sorry.
No, I'm making sure you had me.
Oh, we've got you. Okay,
Oh,
go
boy.
ahead.
Your Honor, today's date and time set for sentencing in this matter. That being said, I had the opportunity to review the pre-sentence report with Mr. Nagel. The only correction I'd ask the court to make, it just is a simple one. It's on the first page where it says place of birth. It says Tecumseh NI. That should reflect MI for Michigan. But other than that, everything is factually accurate. No corrections, additions, or deletions.
Anything either of you'd like to say before I do impose sentence?
Just a few things on his behalf, Your Honor. Mr. Nagel is 45 years old. He does reside in Tecumseh. He's never been in trouble before. He does have 2 children. He's been in a long-term relationship. He just started a new job that he's very proud of. He did accept responsibility for his actions. He was very candid with the probation officer about the incident. He's fortunate that nobody was injured or even worse, killed. With that being said, Your Honor, I think the recommendations are fair. I would ask you to adopt those. There is one caveat. He did indicate to me just recently that he has a pre-planned trip from August 13th through 19th. It's a family vacation to Tennessee, and he's asking for permission to be able to travel.
Sir, anything you want to tell me before I impose sentence?
I would like to just apologize to the court and the people for my actions. Was a bad judgment call on my end, and I appreciate everybody's time and effort. And helping me with this and getting this on the right path.
The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of alcohol education, attendance at one AA meeting per week for the next 90 days, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court, I'll place you on 9 months probation, order $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, $270 probation oversight fees. When can you pay that, sir?
I would ask if it would be possible for me to pay that back in 4 equal payments with the option to pay early if I can do so.
We'll always take your money early. But
Perfect.
when do you want to start this and how much are you going to pay up front?
I can pay $350 up front today.
All right. Pay $350 today, and then it'll be a payment plan as arranged by probation for 3 other equal installments or other installments.
Okay, sir.
There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You are to complete the alcohol highway safety education program. You're to attend 1 A meeting per week for the next 90 days with verification to probation. You're to provide proof of the victim's impact panel attendance to probation. I'll order 93 days in jail, credit for 1. The balance is suspended. I will also order the defendant may travel to Tennessee, and that was the 13th through the 19th. Is that correct, counsel?
Yes, Your Honor.
13th to the 19th of August. Not sure why you want to go to Tennessee, but what the heck. All
I
right.
mean, hey, thank you, sir.
Just kidding. All right, thank you.
Your
Thank
Honor,
you.
can I ask one last question? I had indicated to my client, provided he's in compliance with everything that Your Honor just ordered, he can petition halfway through his sentence for early termination of probation, correct?
Yes, that's provided for by statute, so he can certainly petition. Court makes no guarantee as to whether or not I would grant it, but he can certainly petition halfway through.
Fair enough, Your Honor. Thank you. And should he reach out to the probation department today, or will they contact him?
Yes, he can reach out to me.
Yes, you can reach out to the probation department.
Thank you, Judge.
Could I please get the number to call for that, please?
Sure.
Your Honor, we'll reach out to him.
Okay, we're not giving you the number. They'll reach out to you. No.
Okay.
All right.
Can
All
I,
right.
I'm
you, Judge.
sorry, can I ask one more thing?
I can't stop you. Go ahead.
I work till 9 PM tonight. Is it possible for them to call me in the morning?
Yes, sure.
Yes, of course.
But I
We
need to-
have that scheduled.
But I need to make that payment today. How do I do that?
On your screen,
Yes, sir.
you're on a phone, so you're probably gonna have to swipe screens. There's a QR code. That QR code will take you to our payment site. You can pay by card there.
Okay, perfect. I'll
Okay.
do that.
Okay, I'd wait until I give it a couple hours so we can get the information entered. Okay?
So how I can still find that QR code on the website for the 14A court?
Your Honor, my office number is 734-973-4883. Mr. Noggle, call my office and my assistant can help you.
Thank you very much, everybody.
You're welcome. You're welcome.
Any other questions?
No, sir.
No, thank you.
All right, good. Thank you.
Bye.
Court does call the case, People versus Andre Smith.
Your Honor. Your Honor, good afternoon, Joe Simon on behalf of Mr. Smith. State your name.
Good afternoon.
Andre Smith.
All right.
Your Honor, we have no factual corrections to make to the pre-sentence report. The recommendation is consistent with our expectation. My client is very remorseful and has done a really good job of putting himself in a position to, I think, fulfill these requirements timely.
All right. Sir, anything you want to say before I impose sentence?
I take full accountability for my actions, not only because I've broken the law, but because I've fallen short of the standards that I hold myself to. So I thank you guys for the opportunity to do better.
All right. Sentence of the court, 4 months prosecutor deferred sentence. You're to pay $480 fines and costs, $100 probation oversight fees. When can that be paid?
Everything today.
Fantastic. Pay that today out at the counter. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service as directed by probation. There is no going to any Walmart store in the state of Michigan. I'll set a review hearing that's to be held November 12th, 2025 at 9 a.m. I'll order 365 days in jail that is suspended.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Sherry Walker.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Sherry Walker, who is approaching.
Hi.
Please state your name for the record, ma'am.
Sherry Walker. All right.
Teresa Claire on behalf of probation. Your Honor, Ms. Walker is before the court for a violation of probation hearing. Ms. Walker is in violation of the terms ordered by the court in that she owes a balance of $1,218.78. She failed to do a substance abuse assessment and or treatment. She failed to complete a mental health assessment and or food and treatment. She failed to complete 25 hours of community service, failed to report to probation as directed, and has 4 new pending criminal cases, one being a possession of drug paraphernalia, a retail fraud, second degree, another possession of drug paraphernalia, a retail fraud, first degree, second offense, and a retail fraud, second degree, second offense. All of those incidences happened after being placed on probation. Given Ms. Walker's non-compliance with the probation and her failure to follow through, probation is recommending that Ms. Walker serve 365 days in jail with credit for 13 days served to date to serve the balance, that she complete the in-jail farm program with consideration of early release upon completion, waive remaining terms, accept her financial obligations, and discharge her from probation.
Thank you, Your Honor. I did have the opportunity to meet with Ms. Walker and discuss these violations of probation with her, as well as the jail recommendation. We do acknowledge and admit to the alleged violations, and I would ask to argue against the jail recommendation, however, when appropriate.
All right. Admits to the violation.
Yes, Your Honor.
All right. Go ahead.
So, Your Honor, I was able to have a very long, meaningful conversation with Ms. Walker. And first off, she does want to apologize to the court that she did not complete the terms as ordered on probation. And she does acknowledge that she currently has some pending cases, and I do not want to comment on those as they are still pending, outside to point out that it is my understanding they are all non-assaultive allegations. My client does reside in Ypsilanti by herself. She receives Section 8 housing. Ms. Walker states to me that prior to her receiving Section 8 housing a year and a half ago, she was a resident of the Delana Center. Since receiving this housing, her life has changed in a lot of positive ways, including that she has potential work at a laundromat actually down the street here. She is a caregiver for her mother, who resides in Ypsi. Her mother is 83 years old and is unable to really get around. My client is also engaged at the Hope Clinic on Harriet Street and has even spoken to people there about the possibility of potentially volunteering. My client is very concerned that a year in jail, of course, would leave her likely losing her Section 8, as well as then her current apartment that she's been in for a year and a half. She even stated to me she thinks the TV and the lights are still on at home, and she's concerned about paying rent, which Your Honor's aware is on is usually due on the 1st. In her case, it certainly is that she has to pay her portion of the Section 8. My client states to me that she came into custody when her name was ran and she was picked up. And she states to me that she does not believe any new charges are coming from that police contact. Ultimately, I'm asking the court to consider discharging Ms. Walker from probation without improvement. Closing out this case and not imposing the jail time so that she can maintain her housing.
Ma'am, is there anything you want to tell me before I impose sentence?
Yes, sir. How you doing? Remember I lived in Montgomery, resided in Montgomery, and we did the Zoom, and you had gave me some community work to do, and I was in the Salvation Army, but the husband and wife got in trouble by using drugs, so they closed it down. But I did do some community work there, some hours there, and also I also was going to my court during the through Zoom. I was doing all that. So like when I opened up my blinds every morning, it was a dope house there and the church that I was doing community work there, service there for you. I was just struggling, because I love to open up my blinds every morning. And so, I was doing so well until one day a friend of mine brought up drugs and I forgot I even did drugs. I was doing so well. And so I got back up here. I went to the Delano Center. While I'm on drugs, I was determined and got on Section A. And now I live by myself on the Forge. And I'm the only one with the key. And I do believe I left my lights and TV on. And I don't know no neighbors out there because I was only out there a year and a half. I haven't been out there. And then they're like coming through, because we was on the news about the mold and all that kind of stuff. And so Section A have people coming through certain house apartments to check the the mold and the whatever that's what's wrong with our apartments since it's been what you call it, new management, ill property. But I haven't been on if you could release me to I haven't been on Tether over 40 years as I was in juvenile. I haven't experienced being on Tether as an adult. So if you can please release me, if possible, so I can take care, I don't lose my place in my Section A. And you can put 2 of them on my arm, my wrist, and my ankle. And I would do anything that you want me to do. If you just give me a chance on Tether, I'll pay the fines. I'll drop clean. Because I have a job down the street, the laundromat. I can give you documents of that when I go to work. And also the owner of the laundromat saw my work ethics. And he gave my friend an application to give to me to fill out for as a fill-in. So I have that going for myself and the whole clinic. I have that going for me. And I just can't do everything. I just can't be locked up and lose everything, be back at, on the streets. And the only thing I love, I will show you. I'll drop clean. If you give me one more chance, release me the Tether. I can show you. And then if I mess up then, I swear I'll just do whatever you want me to do. But please, can I go home?
How did you come back into custody?
I was on my friend's house, lived across the street from me. She was about to do my hair. And next thing I knew, they just busted the door down. And they ran my name. And that was that. And that's how I ended up here.
Because I originally sentenced you back in January of 2023. Didn't do anything on my sentence. We had you set to come back April 10th of this year on the violation of probation. You didn't show up. And now we have you back.
Can I respond to that? My mail was going to my mother's address. I didn't have a place then, and she didn't tell me that I had court and then like that. And I'm not gonna lie on my mom, but I didn't have a place then. I just recently got my place, and I didn't know because my mail was going to 2302.
You knew you were on probation.
Yes, sir.
You didn't call probation.
No, sir.
And you knew that you hadn't done anything.
Well, I had started down in Montgomery.
You knew you hadn't done anything on probation. Right?
Sir. But
You'll hold the keys to whether or not you get out of jail. But I'm gonna order the 365 days in jail, credit 13, defendant is to serve balance. I will consider release upon her completion of the jail Dawn Farm program. I'll waive all other remaining terms, including accepted financial obligations, and discharge her from probation without improvement.
what that mean? I gotta do a year?
Calls these people versus Jacob Treadway. He needs to go.
Oh, sorry.
Good afternoon again, Your Honor. Joe Simon on behalf of Mr. Treadway. What's your name, Jacob?
Jacob Treadway.
Thank you.
Your Honor, we're here for sentencing. We have no comments on the recommendation other than to say my client can pay his anticipated fines and costs today. And he's going to fulfill all the requirements the court gives.
Sir, anything you want to say?
I'm sorry for the mistake I made, Your Honor, and I'll learn my lesson. I'm never going to drink and drive again. I promise.
Court does acknowledge this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient programming, weekly attendance of AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court place you on 12 months probation. You're to pay $855 fines and court cost, $100 prosecution recovery cost, $100 police agency recovery cost, $360 probation oversight fees. You pay those today.
Yes, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete outpatient treatment, at Dawn Farms, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with proof of probation. You're to provide proof of the victim's impact panel attendance to probation. I'll continue the sober link testing for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail, credit 1, balance suspended. Thank you.
Thank
Your
you.
Honor.
Court calls the case of the people versus Kevin Smith.
Public Defender Natalie Pate with on behalf of Mr. Smith, who's approaching. Please state your name for the record, sir.
Kevin Smith.
Thank you, Your Honor. I have had the opportunity to review the sentencing recommendation with Mr. Smith, and we are asking the court to adopt it.
Sir, anything you want to tell me before I impose sentence?
No, sir, I just wish that, I know the decisions I've made while under the influence of alcohol haven't been some good ones. And I just wish I would have seen that at an earlier age. That's about it.
Sentence of the court, $125 statutory fee. I'll order 93 days in jail, credit 32 served. Defendant is to serve the balance. He is to complete the in-jail Dawn Farm program. The court will consider early release upon his completion.
Thank you, Your Honor.
Court does call the case, people versus Rebecca Miller.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Miller, who is present via Zoom. Ma'am, can you please unmute and state your name for the record?
Rebecca Miller.
Thank you, Your Honor. I've had the opportunity to review the report as well as recommendation with Ms. Miller. The only very brief correction we have is to her mailing address. She's requesting that apartment 8 be added to that. Outside of that, we have no corrections to the report and would ask that the court adopt probation's recommendation.
Ms. Miller, anything you want to tell the court before I impose sentence?
No, Your Honor.
Sentence of the court, I'll place you on 12 months probation. You are to pay $480 fines and costs, $360 probation oversight fees. When can you pay that?
I need a payment plan, please.
A payment plan as arranged by probation.
Thank you.
There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete an outpatient treatment at Dawn Farms, including all recommended aftercare with status reports to probation. You are to attend a minimum of 3 AA meetings per week with monthly verification to probation. You are to complete 25 hours of community service as directed by probation. There's no going to any Meijer store in the state of Michigan. Under 93 days in jail, credit to the balance is suspended. Thank you.
Thank you. Thank you, Your Honor.
Thank you, Ms. Miller.
Court
Thank you.
does call the case People versus Michael Collison.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Collinson. Mr. Collinson, please state your name for the record.
Your Honor, this is Michael Collinson.
So, Your Honor, I guess there's kind of two pieces of why we're here. There is an allegation of Mr. Collinson's tampering with the tether, I suppose, and then his discharge from treatment. And I'd like to address both. I hope that the court got, I mean, regarding the tamper, I think that, I mean, I've had an opportunity to speak with Mr. Collinson for a long time about both of these issues. Looking at the pictures, to me, it looks like wear and tear. Mr. Collinson was brought in with the tether still on his leg. He was in the jail for, I think, 2 days.
The cuts in the strap are wear and tear.
One of the cuts was, I think, already there. There was like a slit in it. As he wore it a few months ago, he noticed it getting worse. So that has been there for months, and there was no allegation that I did not receive a violation report that it was cut. And I think the second one is kind of similar. It seems to be about the same length as the first cut. And from the rubber in between is kind of looking like it's weakening to me. Again, it was not removed from his leg by him. It was removed by the services group that facilitates the tethers. So he got, the cut is deep, but there's no, if he wanted to, he could have gotten it off. I think, like I said, it's been looking like that for a couple months, and there was no prior allegations that he was tampering with it. He's been wearing.
Saying it is just by happenstance that these two cuts that are almost at equal distance happened, cutting through the one part of it that you're saying it's just wear and tear.
Yes.
Okay.
Yes. I mean, again, if he wanted to get it off, he could have gotten it off. I don't understand
I had no reason to cut the tether.
if he was trying to evade tracking or anything like that. If he did do those cuts, he could have gotten it off, and he didn't. And he came to jail with it on and had it while he was in custody. He's had it since May, and there's been no other allegations of tampering with the tether or evading tracking or anything like that. Again, Mr. Collinson denies tampering with it at all.
Your Honor, I had no reason to tamper with the tether. I ran from the dentist the moment they told me they were going to discharge me. The biggest concern I have here, Your Honor, isn't going back to jail. It's losing the housing that I gained in my sobriety here. I have a lot of, through the blessing of the court, I've made a lot of successful gains. I've completed 74 days in treatment. I never had a behavioral problem at Dawn Farm. The new treatment facility, there was just turbulence. This all has to do with the dental appointment. That's why I get concerned when we're talking about tampering, because I thought this was all to do with being discharged from Oakdale on the leave of absence. I have the the contract. I called Oakdale for pickup at 3:30. I was supposed to return to.
How about I'll start and you can add. So turning to the issue of discharging, I think what Mr. Collinson was starting to say is he went to Oakdale. He was at Don Farm from May to July. He moved to Oakdale because he got housing through HUD, which he would move to that housing at the beginning of August. He has plans for DTE to turn on the utilities on August 6th. So he moved to Oakdale, I think because the program was a week less, he could complete Oakdale and then move into his housing. I haven't been able to contact anyone at Oakdale. I've made a couple contacts and they haven't gotten back to me. But the reason why we think Mr. Collinson was discharged was because he went to this dentist appointment. The dentist appointment was longer than what his out time was supposed to be. And when he called, they said he was discharged because he misrepresented the time that he was going to be done. They thought he was going to be done at 3. He ended up calling them, I think, around 4 o'clock, that he was done with his dentist appointment. The other piece is that from Mr. Collinson's understanding, is that they didn't understand or believe his representations about the seriousness of his dentistry issue. Long story short, he has a tooth that needs to be surgically removed. It's rotting out of his mouth. When he was at Don Farm, they sent him to the ER. The ER can't really do anything because it needs to go through not a normal dentist, but an oral surgeon. Because of the severity of the emergency, they referred him to the U of M clinic. The clinic skipped the normal 4-month wait and got him in for a consult earlier than normal. So that's why he was there. He has referrals from another clinic that he was going to saying that they couldn't do the service because he needed an oral surgeon, because they couldn't find an oral surgeon in his network. That is why he was at the dentist. He did, once he found out that Oakdale was discharging him because of this, he did go to Spera. He tried to get a bed at Spera, and they did not have a bed for him there.
Yeah, you can look at the GPS coordinates, Your Honor. Spera is a safe place for me. Spera is inside the Don Farm community, which I just did all this programming. I had no problem inside of Don Farms. The only reason I went to Oakdale, Your Honor, was to receive this housing. Don Farms is a very open treatment center, so I'm able to go out on weekends with my sponsor. My sponsor is the boss and owner of Home Solutions 101. He's given me employment. He's even helped me pay the DTE that's scheduled to turn on August 7th at Danbury. I'm not saying that what I should have done, Your Honor, is I should have called my facility the moment I found out that the appointment was at 2:30 and not 11:30. I didn't do that. And one thing Don Farm taught me was to own my part. And like I keep going back. I don't know why I didn't do that. It would have. I don't. They say I have a thinking disease, and I don't know why I didn't do that. I should have called them. The only thing I can tell you, Your Honor, is I have 120 plus days clean. I'm before you clean. And that means something to me, and I've gained a lot. I'm not asking for like a let go, but I am asking for like an alternative sentencing that doesn't expand on my homelessness. I messed up the probation you originally given me because I was homeless, and just in this short time to be 5 years homeless and to gain this significant opportunity is really huge for me. My biggest fear in this whole thing, in my thinking, is I don't want to lose this homelessness. I begged and cried on the phone for them to come pick me up. They didn't even give me a chance to show them the paperwork. They didn't give me a chance to drop for them. The wear and tear did start. I ran really fast from the school of U of M on Fletcher Street to Sparrow. Like, I mean, I'm talking, I ran really fast. I've been on tether before. I ran like a gazelle, man. I ran there trying to obtain bedding because my thought process was if I could get into rehab before the violation of tether, that I would be able to argue to you that I did the next right thing. Today I'm at your mercy. I just don't want to lose this housing, Your Honor.
So you're indicating that he's denying that he violated it anyway.
I think, I mean, I know Mr. Conlon is very sure that he did not, or very strong, I guess, in the assertion that he did not tamper with the tether. And I guess the discharge from Oakdale by his representation is a miscommunication about this dentist appointment and how long it was going to be, how long he was going to be there, the necessity around the dentist appointment.
I didn't tamper with the tether. I did not try to take off the tether. If you look at the coordinates, I'm not lying. I went.
Well, he wants a hearing on all of this then. Is that what he's telling me?
I mean, I'm asking Your Honor I mean, he's done, since he was on probation, he did 90 days in Wayne County. I know Your Honor declined to give him credit for that time. He's done time in our jail here in Washington County. He's been clean for, like you said, over 120 days. He's done almost 70 days at Don Farm and Oakdale of treatment. He has housing that he set up. He has employment through a sponsor that he has set up. I'm asking this court to relieve him of his obligations to this court and the remaining balance, given all of the good things that he has done in the last couple of months. I'm sorry?
I let him out to go to treatment.
I did 74 days of treatment. I'll finish treatment. I will. I'm not trying not.
Lara?
Your Honor, I just wanted to make the court aware. I know that Mr. Carlson is no longer on probation in this case. However, I am being advised by the tether agent, so the court is aware that right after he cut his strap and the agent noticed him not tracking anymore, he called and was told that he was kicked out of treatment for a policy violation. They also indicate that they have photos of the tether of when it was installed, and it was a brand new strap, if the court would like to see those.
Well, okay, thank you. Well, I don't know if we're gonna have a hearing. I guess I'm gonna need to see him. I've been dealing with tethers, I don't know how long. I've never seen two parallel cuts or tears, I guess as you're trying to say they are, that are in the fashion that they're in.
And I've dealt with tethers not as long as Your Honor, but I
Wow, that was an age thing. Go ahead.
I do know, I mean, I think the biggest argument here, Judge, is that it didn't come off of his life. I mean, he was tracked the entire time. He didn't, if he wanted to evade tracking, he could have. I mean, people cut them off all the time. And
That's the argument to make, but go ahead.
it wasn't cut off.
That's the argument to make, but go ahead.
It wasn't cut off. And he's represented to me that there was an initial, tear in it, months ago, and
Through the metal.
No, not through the metal. There was a tear in the rubber, Your Honor. I noticed it. We went on a trip to Whitmore Lake from Don Farm, where I was on a paddle boat.
There was a tear in it. Why didn't you go back over to community corrections and say, I need a new strap?
Honestly, the tear helped because it made it looser on my.
Yeah, on the back of your leg at your Achilles heel, right?
Well, no.
That's why it's cut the way it is.
No, Your Honor, it clonks on I have a bony ankle and it just clonks. Your Honor, again, I had nothing. Cutting off the tether would have violated me and that would have made me lose my housing. And my whole point of my whole day, if you look at I got discharged from Oakdale, Your Honor, on that day.
What I have heard is two. One is that these parallel cuts on the back of his tether strap, or on his tether strap, occurred by circumstances beyond your control. The other thing that I've heard is that you were discharged from Oakdale also for something involving the dentistry, and that was also beyond your control regarding the appointment. The only way I'm going to be able to resolve it is if you want a hearing on it. You're not admitting to these violations. And then I'll make a determination.
I don't think Mr. Collinson wants to admit to the violation, so I think we'd ask for a
And we'll
hearing.
set a hearing.
Wait, Your Honor. Setting the hearing is gonna, if I'm gonna lose the housing, I'm gonna lose the housing. Like, what would I be admitting to? Tampering with my tether? Is that what I would admit to, Your Honor? Is that what the violation is saying, that I tampered with my tether?
Correct.
You have two. One is you tampered with your tether. And the other one being that you left treatment.
But okay. I didn't leave treatment.
Sir, I have heard everything that you and your attorney have said.
I didn't leave treatment, so.
You want to keep talking, keep talking.
Oh, I'm just don't interrupt. Okay, I'm sorry, Simpson. I'm sorry.
I'll set a hearing. I mean, that's the best I can do. You can bring me everything and you're saying that there are reasons for all of this, then I'll hear those. But I will tell you with reference to, I don't know in reference to Oakdale, but certainly in reference to the tether, I have great skepticism in what's being told to the court. So,
If I may just explain to Mr. Collinson one thing, Your Honor.
anyway. You just said those other things. Oh, no, we flipped them.
Plead guilty. I mean, plead guilty, see what he does. Maybe he'll let me back to treatment.
Are you sure?
Yeah.
And I've explained to Mr. Collinson that he's entitled to a hearing on the violation. I also advised him that we can call witnesses. He can tell his side of the story to the court. And I think he wants to admit to the violations.
Well, if he's telling me all of this stuff that I just sat here for the past 15, 20 minutes listening to.
Have a hearing?
What?
Yeah, let's do the hearing. You're right. You're right. You're right. You're right. You're right. You're right, Your Honor. Your Honor, is there any way that I can be on house arrest to this new address during the hearing to sign the lease
House
agreement?
arrest will require a tether. We've had our problems with tethers, haven't we? I'll set a hearing in this matter, August 13th, 2025, 3 p.m. This bond will continue as denied until we get to the bond moment. Thank you.
No bond.
Court calls case, People versus Mark Reed.
Good afternoon, Your Honor. Dan Garrett on behalf. State your name.
Marie.
Your Honor, I'll just start by saying Ms. Reed and I.
Karen, court stands in recess. Your fault.
I'm sorry. $50, 100, 108 equals 258. How much time do you need to pay that?
Can I have it taken out of the bond?
You can do that. Did you post the cash or did a family or friend?
I did.
All right, so you'll need to talk to the clerk about how to get that done. And you can do that while you're in the courthouse. But your sentence, 120 days on count 2, suspended for a 6-month probation. You are on probation for 6 months with the condition that you violate no law and that you pay that. I'm going to say within 30 days. So you've got 30 days to get that right with the clerk. And stop by the clerk and they can talk to you about that.
Okay. And they'll take it out of the bond money that I posted.
Yes, as long as your name is on the bond money, yes.
Okay.
All right, Mr. Sweeney, anything further on the Smith case?
No, Your Honor.
All right, then Ms. Smith, anything further?
No, ma'am.
All right, you are excused from these proceedings.
Okay, thank you.
Welcome.
Okay, next one up, I have Mark Dyer, Dyer with a D.
Ready?
I am, he's coming.
Shut my phone down.
All right. And I'm on.
You're on the record in 2025 TR 1310. Bond forfeiture bench warrant, no bond hold.
Thank you, Your Honor.
You're welcome. We'll now be on the record in case number 2025 TR 270, State of Kansas versus Monho Kumar Richavondran. Here in person and first say.
Hi, everyone. Good morning.
Good afternoon.
Yeah, good afternoon, ma'am.
So you are charged with operating without a registration or expired tag in count 1 and no insurance in count 2. Do you intend to have an attorney represent you, sir?
No, ma'am. Like I had a hearing before, and it was discussed that I will be getting into a diversion program, and also like I went to the Butler County county jail, and I also gave the photographs and the bond signed.
All right, you did tell me on May 7th you're going to go through booking and processing for the $1,000 OR. Did you do that?
Yes, ma'am, I did that.
All right, you did that. And then you told me you're going to look into diversion. Did you do that?
Yes, ma'am, I did apply for the diversion.
Did they grant it or deny it?
I didn't get the report yet, ma'am, or like it's been like 4 weeks since I applied. I'm not sure, like I didn't get any update yet. Maybe I should be calling the court and checking on the diversion officer and checking on like what would be the case.
So you did apply. You turned in your application.
Yes, I did apply for my application.
And did they send you a contract or tell you that you were denied?
I didn't get the response yet on that.
Your Honor, if I
I'm
may.
still waiting on it.
Go ahead, Mr. Okay, let's see what Mr. Overgear has.
Your Honor, it would appear that between today's hearing and the previous hearing, a diversion application was received and approved by my office. I am showing that a diversion agreement was circulated by my office approximately 3 weeks prior. However, it does not appear a diversion agreement is on file with the court at this time.
All right, Mr. Richavondran, what you need to do is call the county attorney's office and see where that application is, or that contract is. Their number, are you ready for it? You have their number?
Yes. I'm sorry?
You have the county attorney's number, or would you like me to give it to you?
Can you please call it out?
I'm sorry, I didn't understand what you said.
Ma'am, can you please call out the number? I don't have it. Can you please call out the
All
number?
right, it's 316 321 6999.
Yes, ma'am. Thank you.
You're welcome, and we'll continue this at your request to. Oh, let's see. What date are we going to? November?
November 5th, Your Honor, yes.
November 5?
Yes,
5,
ma'am.
yes.
November 5th at 9, but if you're diverted, you won't have to be here.
I have to be there, you're saying?
If you're diverted, if you've signed your contract and sent it back in, you will not need to be here.
All right, ma'am. And ma'am, I also have something additional to share with the court. Can you go
Okay.
ahead?
Go ahead.
The last discussion when we had, like on the last court hearing, I was informing you, I was informing the court like I would be doing an international travel, and since my parents are not great, I have to be there back in India, and I'm an immigration student. So I came back to India right after signing my OR. Then like I had the case what I had was like no insurance coverage and no registration tag on my car. Later, like I was able to get back onto my insurance, but my car was there back in US, and it was in San Antonio. My friend was driving, and he met with an accident, and the car is total right now. So I don't know like whether I could be discussing the scenario with the diversion officer and asking what could be done, or like would this be the best place to discuss on that?
Go to the diversion, if you would, that, because I don't have any say on what to do about it, other than to take it off the docket if you're granted. So call the county attorney's diversion officer about that.
Uh-huh. Yes, ma'am.
Right.
Sure, ma'am. I'll do that. I'll work it out, work it out with them.
All right, if there's nothing further, we'll be in recess and you are excused, sir.
Thank you, ma'am. I appreciate that. Thanks for the
You're
time.
welcome. We'll now be on the record.